All right. It looks like we are live. Welcome back to yet another BriHive Live, this time on Thursday. How is everyone's week going? We are almost done with the week. Every time I get on live stream, I'm just like super surprised about how fast the week goes. But today, we have a couple of cases to go over. We got a new case, we got a couple of old cases to touch base on and updates going on there. And then we're going to get into the new case after that. So, if you did not read the title, you might not know what cases we're actually covering today. We have three cases to go over. We have Lauren the Mortician case with Jeanette Braun suing the other TikTokers, Rebecca Day, CaffinatedKitti, and Do We Know Them podcast. Don't remember their names off the top of my head, but suing them. And there is an update. There's not much movement going on there. There's been a complaint filed, some motions to dismiss and motions to strike. And then there has been another amended complaint filed. And then we now have a status report and the court kind of getting sassy with the parties on the case because they can't seem to figure out that they cannot email the judge. So we're going to talk about that, and we're going to start off with that case. And then next, we're going to go into the Manzo lawsuit against Bravo. If you missed that case on our channel, this is where one of the Real Housewives of New Jersey sued Bravo for the ultimate girls trip because somebody on the show, Brandi Glanville, allegedly groped her and SA'd her, and Bravo knew all about it. And in fact, Bravo promoted the atmosphere and potentially the actual gestures that was done against her. There has been a couple of updates in that case. We had a motion to dismiss filed by Bravo, but then we also have an amended complaint filed by Manzo. Now, we're not going over the amended complaint today because we have a lot to get through from our third case, which is Joseph Gatt. I hope I'm saying that right. I don't know this guy from a can of paint, but apparently he's on Game of Thrones. If you are Game of Thrones fans, I'm sorry. I don't watch that show, so I do not know this man. I'm sorry to him. I do not know him. But apparently he was accused of, let me see here. Okay. I was like making sure I didn't mess something up. Kimmy sent something to me in the back channel. But anyways, he is being accused of being what can we call him on YouTube without getting in trouble? Being an older man that likes young girls. And when I say young girls, I mean underage girls. And he basically was falsely accused. And there's a whole super long complaint on that. New facts, new case. So we're going to be covering that one last. That one is going to be a pure blind react because I have not been able to read through a lot of it. I did go ahead and scroll there, but I did not get through that one. So that one's going to be interesting. Hopefully we can kind of keep the stream clean so that YouTube doesn't get us in trouble because we've gotten a couple of yellow flags over the last couple of weeks because of the topics that we have been talking about. So before we jump into the chat, go ahead and drop, if you're watching live, let us know. If you haven't hit the like button, please do. It does help us out in the algorithm and it helps us get more friends in the BriHive. And if you are here and you're not subscribed, but you like coming back, or even if you don't like coming back, go ahead and subscribe to the channel. I am like fighting to break this $13,000 subscriber follower or subscriber count. Get it together, Ree. Maybe that's why you don't have subscribers. But anyways, I am trying to break it. So if you have not subscribed, please do subscribe because we love you here and we want you to keep coming back. And we want to hit 13,000 subscribers on the BriHive Live. Or not on our live, but on our channel. You know what I mean. Anyways, let's go ahead and set the like goal for the live stream. We have 17 likes. Shout out to the BriHive. Hitting the like button on your way in because there's only 20 people watching live, or not only 20 people, there's a wonderful 20 people watching live, and 17 have hit the like button. So there's at least three of you that have not hit the like button. So if you haven't already, please do hit the like button. It does help out the stream. And we're going to go ahead and set our like goal at 75 likes. Now, remember, last time we did not meet our like goal. We do not want to be BriHive from Tuesday. We want to be BriHive from last week where we met our like goal, I think both on Tuesday and Thursday. So if you haven't hit the like button, please do. We got fun graphics. Maybe they're not so fun because I haven't fixed them yet, but fun graphics nonetheless, in my opinion. Anyways, let's go ahead and jump in the chat. If you're watching live, make sure to say hello so that we can say hello. Bossy just completely cut me off. And when I'm saying bossy, I'm talking about myself because I have to click the button. Anyways, go ahead and drop and say hello if you haven't already so that we can say hi to you. All right, we got Tanya D, also known as Destined to Be, and that all rhymes. Welcome back into the live stream, member and moderator of the channel, saying swinging by early to remind everyone to hit that like button on your way in, or else Bossy the Bee will be upset. Bossy the Bee was a little upset. She cut me off, okay, while I was still in the middle of a sentence. Welcome back to the live stream, Tanya. Nice to have you back tonight. We have Amy Evans, another member of the channel. Welcome back, saying, did it? Hit that like button. Love to see it. Carolyn Lower saying, good evening, another member of the channel. Welcome back. Welcome back. YR, another member, saying, hey, everyone. Hello, hello. And a lot of the chat are members because we had some wonderful people come through and gift a lot of memberships. And then we have some loyal members that they're in the membership every month. And I appreciate everyone so much for being a part of the membership. If you don't know about the BriHive membership, it is $4.99 per month. It supports the stream. You get cool badges, cool emojis, and you get to come on the BriHive live stream with the members, which I'm going to be posting about adding members to, not adding members, but doing the members live stream. It's usually on the weekend so we can get the best chance of all the members coming and joining us live. So I need to post that soon before some of the gifted memberships expire. But hello. We got Carolyn Lower. Welcome in, saying, did you watch the hearing last night for Brian Koberger? I know I spelled that wrong. You actually did not spell that wrong, if I'm knowing the spelling. But no, I didn't. I didn't even know there was a hearing. What happened? Y'all, I've been working in court. I have court tomorrow. So no, I did not even know anything happened with Brian Koberger. What happened, if you know? Runkle of the Bailey, hello. Welcome into the live stream, saying, hey, folks, y'all, if y'all are not following Runkle of the Bailey, he has wonderful content. So I know a lot of people on my channel came from Rob's channel, so you probably are also on Ian's channel. But if you're not on Ian's channel, make sure you go and subscribe to him. Carolyn Lower saying hi to Ian. We got Kristen Carney, another member of the channel, saying, hope you're having a good day. I had a long day. I had a very long day, but I hope everyone else is having a good day. We got Time Lordess saying hi, BriHive, another member of the channel. Hello, welcome back. We got Mary Malarkey, member and moderator of the channel, saying hello, Bri, and chat, dropping the B emoji that is exclusive to BriHive members. Okay, I need to add some more. I think you can add like more badges or more emojis after a certain amount of time. So I need to look into doing that. Get back into my creative realm of creating these things. Runkle of the Bailey saying, gonna have to be replay crew, but hopefully send some folks to check out things, including the Janet updates. Thank you very much. Definitely appreciate you stopping by and sending people over. It's not a lot of updates on Janet, but we do have some other cool cases to go over. Thank you, Runkle, for stopping by. Mary Malarkey saying hi to Runkle. Boss Attorney Bri, which is me, which I believe is Kimmy, saying hello and happy Thursday. BriHive dropping the Bri emoji. Oh, do I get the B emojis? Like, I'm not even a member of my own channel. Can you be a member of your own channel? That would probably be counterproductive though, right? Because I shouldn't be commenting. It's Kimmy. Josie B saying, hey everyone, hello. Welcome in, another member of the channel. Lola Waterton saying, have a good night to Runkle of the Bailey. Thank you again for stopping by, and hello to Lola. Welcome into the chat. Alexis Carney says, stuck on the legal side of YouTube lives, like I'm not addicted. I can stop anytime I want to. Well, we like you coming here. So you know what, things that you get addicted to do to you, it makes you want to keep coming back. So that just means that I and all of my fellow legal side of YouTube is doing a wonderful job covering all of these topics. So we're happy to have you addicted. We are happy. Usually we're not happy about addictions, But for this is okay. I think this is a clean addiction, right? Janine says, hey, Runkle, hello and welcome in. Janine, welcome into the live stream. Melissa Sima, another member of the channel, saying BriHive with exclamation points. Hello, welcome in. Nice to have you here. We got Chantel saying, hello, everyone. Another member. Hello, welcome back into the live stream. Carolyn Lower says, we are professionals. We are trying to be professional. Did I do something bad? I feel like that's what's said when we mess up. Did I already mess up? Kimmy Locker said, hello and happy Thursday, BriHive, and boo to YouTube for switching between accounts for no good reason. Sorry for sorry for impersonating you, Bri. It's okay. I'm like, how am I talking? Am I a ghost? I have a ghost channel. Kimmy, I remember moderator, consultant and paralegal of the channel, grabbing all the documents for us, all the important parts of the docket for us. Shout out to Kimmy, y'all, because she went and highlighted changes in the amended complaint for the Manzo lawsuit. And we're actually not going to get to that tonight, but we will probably cover it on Tuesday next week. So shout out to Kimmy for that. Let's do my home. I don't know if Deacon Fatal is in here, so sorry if you are. Frankie Smith dropping a B. Hello, welcome in. Runkle of the Bailey saying, Bree, later on send me the timestamp for when you start the Janet, and I can link it to some other folks later. Okay, awesome. Thank you. I will do that. I'll send it to you on the Twitter X. What do you call it? Is it called X or is it called Twitter? I will send you if you can help me with the timestamps today, because I'm really inconsistent with doing timestamps. Alexis Carney says, I have been lucky to be blessed with memberships for channels multiple months in a row just by showing up to their lives. Love that. I love that. That means you are dedicated and you are supporting the channels, and we love that. We love that for you, and we love that for us. We appreciate it. Dragon's Angel, another member, saying, hi all. Hello, welcome in, welcome in. I think that was also, we got more coming from Runkle in a moment. Kimmy Locker saying Koberger's attorney did a survey of potential jurors that the state was big mad about. How did they get potential survey? How did they do that? I don't know. Let me stay out of criminal court's business. They can do a survey before they become jurors or before they get the juror notice. When is his trial? His trial is like in October though, isn't it? Or am I making that up too? Runkle of the Bailey says, also, sometime we need to do a joint live talking about Janet because she is hilarious. Yes, we do. Yes, we do. It's going to get insane. Like the fact that they have come out with a status report, which is what we're covering today, this thing is going forward. Like this is going forward. They are not pausing on it at all. So I would love to do that. Destined to Be, also known as Tanya D, says, I'm back. Hello to everyone. Hello and welcome back. Nice to have you back, Tanya. Carolyn Lower says the cross-examination was spicy. The prosecutor called the expert whiny and asked him if he was about to cry. I have to go back and watch that. I did not know that came out about Brian Koberger. Jeez. Not about him, but for his case. I haven't been keeping up with that case that well anyway, so my fault. Kimmy Locker says, OMG, yes to the joint stream. Yeah, no, we're going to do it. We are going to do it. When? That would be the question. Phoenix Waller said, another member saying, yes, both of you chatting Janet would be great. Is Janet going to come after us as attorneys though? Like, will we then be promoted to rogue attorneys if we do this? Like... That would be amazing. Tanya D saying that would be great to Runkle of the Bailey doing a joint stream talking about Jeanette. Y'all gonna get me in trouble. Smalls, another member and moderator of the channel, saying what's good, BriHive. Hope everyone is well. Welcome back. Nice to have you back. Hope you are doing well. Happy to have you in the chat tonight. Chelsea B says definitely a Bri and Runkle stream. Gotta do it. We gotta do it. It has now been voted upon. That is the census of the live stream. Runkle and I are going to do a live stream on Janet. Alexis Carney says, oh, I want to see a live with Runkle, Bri, Natalie, and Rob. I heard that Rob was on Natalie's channel not too long ago. I completely missed it. But no, that would be really fun. That would be really fun. Let's see. Dragon Angel says joint stream would be epic. Would love it. I love when the different channels get together and the different personalities, and It's always a fun time, and there's always going to be a moment where it's just hilarious. So I'm for it. I am for it. Just Me MD says, drop it in to send some love from East Texas. Can't stay. Day 3 of severe migraine cycle. Sorry to hear that, Just Me MD. I'm happy that you stopped by. Saying today is pretty rough and intense, so can't stay. Back to bed. See you guys on Tuesday. Well, we hope you get better soon. I'm sorry that it's a 3rd day cycle. Hopefully it gets better soon. Kimmy Walker saying, join the BriHive and dropping the link. Thank you for that. Yes, if you want to become a member, Kimmy dropped the link for it. I need to fix the join button on my my channel page that Rob told me to do like a month ago. So I'm gonna work on it. Alexis Carney, I'm getting behind in the chat because I'm seeing that Kimmy starting the star stuff for me. So let me speed it up here. Alexis Carney saying, I'm a recovering alcoholic, so I'd say this is a good addiction to replace my former one with. Yeah, I love that. I love that. Swap it for a positive one. And congratulations on being recovering alcoholic sober. So thank you for sharing that with us. Janine says, oh my gosh, a Brie and Runkle collab on Janet would be amazing. I agree. We're going to do it. We're going to do it. We'll be in the X DMs. That sounds bad. Get into the X DMs. You do not want to send DMs to your ex. So freaking Elon Musk needs to change X back to Twitter. Okay. MB says to Alexis Carney, congrats on your sobriety. Great work. Yes, I agree. Tanya D saying, yes, Alex Carney, much. I think she meant Alexis. Alexis Carney, much better. And we are in support of it. Alexis Carney say, I appreciate you to MB making 5 years sober this year. Awesome. That deserves a round of applause. 5 years. That's a long time. I tried to commit to not drinking, and because I'll drink a couple drinks per week, mostly on the weekends. And I tried to commit to it for like 30 days, and I got 2 weeks through it. So we're starting it back over. That's amazing. That is amazing. And congratulations to you. Let's see. We have Just Me MD saying, Smiles, I really enjoyed your live last night. I learned a lot signing the ASL alphabet a lot today. Oh, going to be signing the ASL alphabet a lot today. Well, that is awesome. I missed the stream last night. I'm going to have to go back and check it out. Joe W saying hi, another member of the channel. Hello and welcome in. Let's see. Jazzy G, another member, saying hi, Bree and chat. Hope everyone had a good day. I hope so too, y'all. I had a long day, and I feel like I'm going to have a long day tomorrow. I've been having a long week, but I hope everyone is having a wonderful day, and hopefully this stream can make it better. I am behind, aren't I? I'm really behind. But we love when I'm behind because that means the chat is really interactive, and we love when the chat is interactive. So keep chatting, guys. Mary Malarkey says to Alexis Carney, yes, Bree, Natalie, Rob, and Runkle would be a fun live. I missed the group live stream. So many wonderful content creators coming out of the DEP trial. Yeah, that is true. A lot of people did come out of the DEP trial, and I would love to do it. We can make it happen. We can make it happen when everyone's schedule, we'll have to see. Alexis Carney says, I honestly had to learn how to schedule emails from watching Runkle's coverage of Hannah Gutierrez Reed, because I was doing my work at midnight and was like, okay, gotta send these for business hours. That's amazing. That's so fun. Darlene, another member of the channel, welcome back, saying they did a survey of potential jurors in Latham County with some troublesome questions. It's to determine if they need to change venue. Okay, that makes sense. That makes sense because he's not going to want to be there where everyone is kind of against him, which is hard not to hear about that case. So, let's see. We got Sheila saying to me, I just go watch Runkle's live last night for the Idaho update. Yeah, that's what I'm going to do. I'm going to check out some of our people to see what has been covered. Small says, my year is made seeing Olay in NLC today. So Bree times Runkle would be icing on at this point. Oh, yeah. No, we're going to do it. Now I'm committing to it. I have to follow up now. We have been summoned to to talk about Jeanette. We're going to be promoted to rogue attorneys, and I really just can't wait. MB says, I must go to bed. It's way too late here. Wish I could stay. I guess I have to be replay crew. That's okay. Thank you for stopping by. Hope to see you in the comments on the replay crew. All the happy girls and other members, and I'm late. No, it's okay. It's okay. There's no such thing as being late to the BriHive Live, okay? Small says, what is there to fix, though? Your join button is fine. Rob had said something about for certain computers or like Androids. I don't know what he said, but he's like, there is no join button there. So he said to put a link there. I don't know. Clearly, I need to update my full channel page. So there's that too. Carolyn Lower says, I may have to be replay crew too. I didn't get any sleep last night. Well, get your sleep. I know how that feels. Get your sleep. No offense here. Get all the rest you can get. Alexis Carney says, I think the one thing I love about this law community on YouTube is the way y'all engage with and build community. It's really cool to see. I appreciate you. Well, we appreciate having you here. And it is really fun. It is like a separate, I don't even know how to explain what it's like, but you have these internet friends, even like you guys in the chat. I feel like I have all these internet friends that are like supportive, and we can talk about different things going on in our lives, all while we're talking about the law and the trouble that's going on in other people's lives. And everyone is just super supportive, especially the other people that stream. Everyone has been super supportive. And I credit it, and if there was somebody before her, I'm sorry for it, but I credit Emily D. Baker. She definitely encouraged me to start live streaming about the law. And then I know that she's connected with a lot of the other legal community that live streams too. So I credit legal live streams to Emily D. Baker. If somebody else was before her, I don't know, but I credit it to her, and I appreciate that from her. Kimberly Rudd saying good evening. Hello, another member of the channel. Welcome in. Kimmy Locker says, you're not super behind, but there were some retracted messages. Okay, which was to show retracted StreamYard. Okay, yeah, it doesn't show us StreamYard. So, and then people talking, chatting, which we love. We love the community, right? Thank you, Kimmy. Alexis Carney says, speaking of ASL, I'm deaf, so my live streams are English and Pidgin signed English. Oh, wow, that is good to know. And that's why I'm happy. Like, I do my closed captioning all the time so that everybody can enjoy the stream. And when I accidentally forget to turn it on, I'm like panicking, okay? I'm panicking. And then we have Smalls dropping the link for the Apple users. Just need to add the join at the end of the creator's custom link. Thank you for sharing that, Smalls, also known as Hella Swanky. You're going to like replace your name, Hella Swanky, in my head with Smalls. Like, I don't even, come on. Why would you do that? Why would you do that? I like Smalls too. I mean, I guess it's not that bad. It's me. It's not you, okay? Alexis says, being an admin for a live is hard. Thank you for the admins and hosts for making these live streams happen. Yes, definitely appreciate it. I would not be able to do this without my moderators and without Kimmy acting as my paralegal of the stream. I probably would have had to stop live streaming if I did not have Kimmy helping me because of all the things that go on in work, during my personal life, and then prepping stuff for live streams. And I like bounce ideas off Kim. Like, I appreciate Kimmy so much, y'all. I literally texted her this morning. I was like, I have not seen any cool ideas or any cool cases come out. Do you know of any? And she literally did our docket for today because she keeps up with things. She's better than me at keeping up with things. So yes, shout out to Kimmy. Thank you for that. All the happiest girl says to Alexis Carney, so true, but the mods are so vital for helping to create these LawTube communities. Agreed. And the chat too, just to keep the interaction, right? The chat, even if you're not a moderator, you are important to the stream as well. The moderators definitely save me on a lot of things though. Definitely save me, especially when people come in trolling. Alexis Carney says, yes, and when you forget, I use a different, captioner. It's less accurate, but better than nothing. Okay, that makes sense. Well, like I said, I continue to try to remember, okay? But sometimes, we're human. We do make mistakes. Baby Meatball, another member of the channel, saying, hey, everyone, dropping a B. Hello, welcome back. Nice to have you. Still love that name. Still love it. Mary Malarkey says, I started with Emily D. Baker and Legal Bites during the Depp trial. Okay. I want to do that one stream, figure out where everybody came from. Cheryl C says, hi, everyone. Another member and moderator of the channel. Welcome back, Cheryl C. Hi, welcome in. Hope your Thursday is going wonderful. Lady Draken is saying, hey, another member, welcome back. I feel like I haven't seen you in a couple of live streams, but welcome back. If you have been here, I'm sorry if I was missing you there. Small says, laughing my A off. I don't know why it doesn't show up as hella swanky in the chat because I changed it back. I changed it back just for you, Bree. I don't know. Well, for me on StreamYard and in the chat, it's showing up as Smalls. I just thought you had a different channel. All the Happy Squirrel says, sorry if I'm distracted. I'm catching up on 2 times and looking at dogs on Pet Finder. Love that for you. Now that I've finally gotten the hubs on board. Lucky you. Congratulations. I hope you get a wonderful dog. The Lady Draken says, modding is fun for LawTube community. Yeah, I think so. There's a lot of room for streams to go wrong. And so, yes, the mods are definitely needed. Okay, y'all, in a second, I'm going to have to go ahead and jump into the cases that we're covering today. Rachel Mill says, question, would you like a copy of the charges brought against Otani's interpreter? Someone posted the federal charges. I'm not familiar with that, but sure, yeah, you can send it over. Most active, or I'm not most active, but if you tell me you're going to send something to the Twitter DM, I will be on Twitter to get it. So you can send that over. I'm not too familiar with that. Island says, hey, BriHive, hello, another member of the channel. Welcome back. I don't know why that message was hard to read. I think it was hard for me to focus. John Smith says, I blame Law and Lumber. For what? Why are you blaming Law and Lumber? What are you blaming on him? Welcome back, John Smith. Lady Jerkin, says, I try to make it on as much as I can, but I'm on the East Coast and I get up early. It's no problem. I was just saying I missed you. Happy to have you back. No, definitely understand. If I was not doing the live streams, I probably could not make every single one. But when I have people that come back on the regular, I'm like, super used to seeing their name, and if it's been a while, I'll be like, oh, I haven't read that name out in a while. So no shame, okay? It is fine. Get your rest. I say that all the time. The rest is the most important thing to do. So let's go ahead and jump now that we've chatted for about 30 minutes. Saying hello to everyone in the chat. Feel free to keep chatting. Kimmy is going to be starring the chats, or I should ask her, not just say she's going to do it. Kimmy, can you please star the chats that are talking about the cases that we are going over? And y'all still feel free to just chat amongst each other in the chat, and we'll be reading the ones that are relevant to the topic that we're covering. So let's go ahead and have Bossy B bring us in. Okay, who do we have? We have Lauren the Mortician and Jeanette Braun's lawsuit going forward. Like, this is a lawsuit that we all thought was just going to kind of, cause some friction and then go away. It's not going away, y'all. It's literally not going away. And we know it's not going away because the parties have compiled a joint status report to let the court know what is to be coming in this case. And then they have to come up with a little bit more of a calendar to tell the court exactly when documents are due and how things are going to go forward. And there's an interesting little statement about mediation in this status report too. So let's go ahead and jump into the status report, and then we'll talk about the attorneys and or parties. I hope it's not the parties that are going rogue and emailing the court. Now, there is an attorney in the lawsuit that is the plaintiff, alleging that she's falsely called a rogue attorney. So I really hope it's not her emailing the court staff. Anyways, let's go ahead and jump into the lawsuit, or jump into the status report. For those of you who do not know this case, this is Jeanette Braun IP Law, and Lauren Propson, also known as Lauren the Mortician. They are TikTokers, or Lauren is a TikToker. I guess Jeanette is kind of a TikToker. Everybody calls Jeanette Janet, and she thinks that's mean for people to do because they're making fun of her. Besides the point, it's funny. That's why we're calling her Janet. they are TikTokers, and Jeanette Braun is a TikToker and also was Lauren the Mortician's attorney, sending out cease and desist letters to the defendants, Rebekah Day, Box, Casey, Rebekah Day, okay. Rebekah Day, then Casey, the owner and operator of CaffinatedKitti, Lily Marston, and Jessica Vasquez. I know I'm gonna say it wrong. I say it wrong every time. Vasquez. I think that's it right. Vasquez. Which one is it? I don't remember. Anyways, they're suing these other TikTokers for basically talking about them on the internet. We got some copyright infringement going on, or alleged copyright infringement going on. We got some defamation going on. That's where we're talking about the rogue attorney and being an unethical attorney. Most of this lawsuit, although people call it the Lauren the Mortician lawsuit, Lauren the Mortician only has claims against one party, while Jeanette Braun actually has claims against all the parties on the lawsuit. So to me, it's Janet's lawsuit, not Lauren the Mortician, but Lauren the Mortician, I guess, is more popular, so everyone calls it the Lauren the Mortician case. So let's go ahead and jump into this joint status report. They have all come together to go ahead and let the court know what's going on. They've identified the attorneys on the case. And then we have the state's basis for federal jurisdiction. It is subject matter jurisdiction. Casey contends that Probson's claims should be dismissed under improper venue. Remember, we're under diversity jurisdiction where the parties are from different states, different jurisdictions, right? But it has to be states. And the claims are claiming something $75,000 or more. They go ahead and describe some of the nature of the claims asserted in the complaint. Plaintiff asserts separate claims against defendants for defamation, false light, trade libel, tortious interference with business, and intentional infliction of emotional distress. So they're just taking those 30 to 50 pages of complaint and condensing it down into 3 lines of text? But we like the details, and that's why the complaints are so long. The plaintiffs, which is Jeanette Braun and Lauren the Mortician, and also Jeanette Braun's law firm, they filed an amended complaint on March 21st, which we did go over on this channel. The court has set April 22nd, 2024 as the deadline for defendants to file an answer or other responsive pleadings, including like motions to strike, motions to dismiss. They have already filed some, but now they need to file it against the new amended complaint. Defendants are presently evaluating whether additional time for a response is needed based on new allegations in the first amended complaint, and will raise such requests with the court if necessary. They want to describe the relief sought from the plaintiffs. They're essentially asking for injunctive relief, stop saying mean things about me, and also apologize to me online. Compensatory damages, pay me for the money that I lost for you guys being rude to me, and punitive damages, pay me more money because you did bad things and you need to be punished. And they also want attorney's fees because they've had to bring this lawsuit and they want to be reimbursed their attorney's fees. The defendants dispute that plaintiff claims entitle them to the award of attorney's fees and costs. So they are only disputing the attorney fees and costs. And then I guess if they dismiss the claims, then they won't get the other ones as well. So let's see here. Am I not showing the screen? Oh, was that a while ago? I just got your message, Kimmy. Is that a while? No, I'm showing the screen now, right? Y'all can see the screen, right? Now I'm like second guessing myself. Okay. And then let's go into the major legal and factual issues in the case. And this is, like I said before, this is what they condensed it down to between the plaintiff's attorneys and the defendant's attorneys. So let's go on to the legal and factual issues in this case. According to Plaintiff Probson, the question is whether defendant KC made a public statement to third parties knowing them to be false. Second, according to Plaintiff Braun, whether defendant Day made public statements to third parties knowing them to be false. To Plaintiff Braun, like I said, this is Braun's lawsuit because she has all the claims. She asked whether defendant Vasquez made public statements to third parties knowing them to be false. Same thing with Braun against Martin. And then we have Plaintiff Probson, whether false statements made to third party by defendant KC implicate Plaintiff Probson liked transphobic content and thus is transphobic. According to plaintiff Braun, whether defendant Day's statement to third parties that plaintiff Braun is an attorney using an unethical tactic of a false copyright strike is representations of her client's dimps implicate that plaintiff Braun is an attorney lacking ethic and competence in her profession. According to plaintiff Braun, whether defendant Vasquez statements to third party that plaintiff Braun is an attorney using unethical practices and filing of false copyright strikes and representations of her client implicate that plaintiff Braun is an attorney lacking ethics and competence. So same thing for Vasquez and who else was that? Day, saying that she was unethical, allegedly. According to plaintiff Braun, whether defendant Martin's statements to third parties that plaintiff is committing perjury in her representation of her clients would deem her as lacking ethics and competence. According to plaintiffs altogether, whether in making the above public statement, defendants each acted with actual malice and reckless disregard for the truth, which I am surprised that they are using that standard, because I would argue that I'm a regular person. I'm just on TikTok. I don't have any notoriety to be under the actual malice standard. Interesting that that's the standard that they're going for. So there's that. Let's see. According to plaintiff Propson, whether defendant Casey's statements to third parties were intended to interfere with Propson's contract for brand endorsements and sponsorships. According to plaintiff Braun, whether defendant Day, defendant Vasquez, and defendant Martin's statements to third party were intended to interfere with Braun's contract with current clients for legal representation. According to plaintiff Propson, whether defendant KC's statement to third parties were intended to inflict emotional distress on plaintiff Propson by inciting an internet mob to harass plaintiff Propson and her sponsors. According to plaintiff Braun, whether defendant Day, Vasquez, and Martin's statements to third parties were intended to inflict emotional distress on plaintiff Braun by inciting an internet mob to harass plaintiff Braun and her client. So we got internet mobs going after Braun, okay? Interesting way to put it. Let me go ahead and stop for a minute because I do see some super chats coming through. So let me go ahead and read those. We got Deacon Fatal. Welcome in. Welcome back. Saying, thank you for the $5 super chat. Definitely appreciate that. Saying, it's Janet, miss. No, that joke won't work here. I still think she is nasty. I'm sorry about that. Deacon Fatal also says, question, are all entertainment lawyers this spicy? I guess it depends. This is actually a joint statement, so I don't know how to answer that question. What do y'all think, Chad? Do you think all entertainment lawyers are spicy? I think a lot of plaintiffs' attorneys are spicy because they have to make the complaint spicy enough. But I guess the defendants will also be spicy because they have to make their claims back about them spicy as well. Same thing with the motion to dismiss on Manzo. The Bravo is spicy. Like, girl, you knew what you was getting into. So I'm going to say yes. Defendants' legal and factual basis. Let's go ahead and see what they are. And again, thank you for the super chats to Deacon Fatal. Okay. Defendant asserts that parental let's get it together. These are the defendant's legal and factual issues. Whether plaintiff Propson and plaintiff Braun's claims violate anti-SLAPP statute under Georgia and California. Remember, we read some of the motions to dismiss and strike, and they're claiming anti-SLAPP for the Georgia and Californian defendants in the case. Whether this court is the proper venue for claims asserted by a Wisconsin citizen against citizens of Georgia, California, and Missouri under federal rules civil procedure 12B3 is this the proper venue, and that one is against Propson. Should Propson be in this case when she does not have any claims against some of the citizens or some of the parties, some of the defendants in the case? Whether allegations of the amended complaint state a claim for defamation, false light, trade libel, tortious interference of contract, tortious interference with existing and potential business relationship, intentional infliction of emotional distress under the substantive law of Illinois or Wisconsin, and under federal pleading requirements. They also ask whether the statements allegedly made by defendants constitute defamation, false light, or trade libel under Illinois or Wisconsin law, whether the statements allegedly made by KC regarding plaintiff process constitutes tortious interference with contract and intentional infliction of emotional distress under Wisconsin law, and whether the statements allegedly made by defendants regarding plaintiff Braun's constitute tortious interference with existing and potential business relationships. So they basically made a claim. Does that actually satisfy against the defendant? Do they actually have these claims, or are they missing some elements that they have to prove? Were they acting with actual malice? Did they interfere with business relationships? Did they do it intentionally? Did they do it negligently? Those are questions that need to be asked. Okay, let's see. We got a case plan coming forward. The court or the parties clarify that they identify any pending motions. The defendants filed a motion to strike the original complaint under anti-SLAPP statutes, and alternatively motions to dismiss under federal failure to state a claim and also improper venue. The court deemed these motions moot upon plaintiff's filing of the amended complaint. So basically, if the defendants want to answer by filing a motion to dismiss or a motion to strike, they have to refile that and basically do another document. Now, remember, they did add a few new things in the amended complaint, so they would need to address those new things and remove the old things that were removed. A lot of it was similar, but the plaintiffs did give a little bit more detail in where they were coming up with the claims. Okay. The next thing is state whether any defendant anticipates responding to the complaint by means of motion. If so, the basis of the intended motion. The defendants let the court know that defendants intend to file motions to strike the amended complaint under anti-SLAPP statutes, and alternatively motions to dismiss under failure to state a claim and improper venue. So their previous motion is moot, but they plan to file another one. Submit a proposal of a discovery plan. They go ahead and say that they need to do written discovery for the allegations and claims for damages. The parties intend to serve deposition notices. So they're going to interview a deposition. They're going to have Braun under deposition, Lauren the Mortician under deposition, the defendants under the deposition, and they'll also have expert discovery as well to see if any of these claims really hold any water. Whether discovery will encompass electronically stored information and any anticipated issues about disclosure discovery. The parties contend that discovery will encompass electronically stored information, and that much, if not all. Yeah, it's gonna be all, because all of these people are in different freaking states. And how are they communicating? Freaking electronic means, TikTok, email, GoFundMe pages. So a lot of the information is going to be electronically stored and hard to print out. You got video, right? So they go, the information, much of it, if not all of electronically stored information, will be copied and distributed between parties on portable digital storage media and or Dropbox as noted below. The parties request a stay for discovery pending during the pendency of the motion to dismiss. We'll talk about that a little more later on. Any issues about claims or privilege, any issues about claims or privilege or of protection as trial preparation materials, including if the parties agree on procedure to assert these claims after production. The parties are not aware of any current issues relating to claims of privilege or of protection as to trial preparation materials, but will agree to a procedure to address any such issues if they arise. Plaintiff believed there may be that's why I was like, what about the attorney-client privilege? Plaintiff believed that there may be attorney-client privilege and attorney work product issues, as well as other privilege issues of the case. So are you not going to want to show us your filed copyright complaints? A date for the 26A1 disclosures. Plaintiff proposed 30 days after the resolution of the motions to strike/dismiss. Defendants propose setting this date after resolution of the motions if necessary. I don't know what that is off the top of my head. They have discovery completion dates to be set by the parties after the motion to dismiss and motion to strike, whether expert discovery is contemplated, and if so, the dates for when it must be completed. The parties propose setting this date after the resolution of basically all of this is going to be set after the resolution of the motions to strike or dismiss. They also have interrogatories where they can ask questions on paper. Same thing with the depositions. They're saying that they should be decided after the motion to strike and dismiss has been done. With respect to trial, provide the following information. A jury has been requested, and the estimated length of trial is 5 to 7 days, which doesn't sound long, right? That sounds like a pretty quick trial to be going through 4 defendants. 4 defendants, and you're only estimating 5 to 7 days. I mean, I guess, yeah, but then you have to have the plaintiff, so that's 6. I would give them probably each a day for their testimony, because they claim that several statements are defamatory for each of them. So yeah, the 5 to 7 days doesn't sound like enough time for me. But anyways, this is their case, their business, not my. I mean, I guess it's kind of my business because I'm talking about it on the internet, but their business nonetheless. Okay, settlement. Whether any settlement discussions have occurred. So, as we know, or maybe not as we know, we thought that this case was going to be dismissed. It was going nowhere. They were going to be in the improper venue, improper jurisdiction, not have diversity, all of the things. So the court is asking whether there has been any settlement discussions. The parties say there have not been any settlement discussions to date. However, the parties believe that a settlement conference would be productive following the court's ruling on the anticipated motions to strike and dismiss. So while they have not engaged in settlement discussions like Diddy with Cassie and settled the case in less than a day, they do think that they would be able to get some progress after the motion to strike. So once we can figure out what claims the court deems are legitimate, maybe we can start talking about this, right? Let's see which ones are dismissed by the court, and then we can kind of narrow our issues to determine whether we can settle this thing. Now, is it gonna settle? Probably not, because I think that Lauren the Mortician and Jeanette Braun want to be vindicated, and they want their money for having to file this lawsuit. That's my opinion of it. They basically consent to having the magistrate judge let me go ahead and read it because I'm trying to make a summary of something I didn't read all the way earlier. Okay. State whether counsel have informed their respective clients about the possibility of proceeding before the assigned magistrate judge for all purposes, including trial and entry of final judgment, and whether the parties unanimously consent to that procedure. Plaintiff has discussed the possibility of proceeding between one magistrate judge. Plaintiff would prefer to conduct discovery and settlement matters before the magistrate judge. So they only want the magistrate judge to hear the discovery and settlement matters, and then they want a different judge to hear the actual trial if it goes to trial. Defendant has discussed the possibility of proceeding before a magistrate judge for all purposes, but respectfully declined this option. So they do not want to go for the magistrate judge for all purposes. They're going to want different judges for different parts of the case. You want them to not be as familiar, not to form biases, already have their bias in place. If you have the same judge, they're going to be like, okay, freaking the plaintiff's attorney was annoying last hearing and they're annoying every hearing. But if you have different judges for different issues, then maybe you don't have that same annoyance with the party. So I think it's a good strategy to kind of let judges go in blindly. But it's also frustrating for the parties because like, oh, they don't remember my case. That happens all the time in my case. They don't even remember my case. They don't remember my case. Yeah, because you got 4 different judges in the last year. Okay, I'm going to go ahead and go over the minute order updates, and then we'll go ahead and jump in the chat. So if you have comments about this case, make sure you go ahead and drop it in the chat, and we're going to get to it in just a moment. Let me share the screen again. Okay, we have some minute orders entered, but before the Honorable Judge Mary Rowland. This court has reviewed the status report. The court is not inclined to stay discovery pending Rule 12 briefing and anti-SLAPP briefing. If person status hearing set for April 17th. So coming up here soon at 1:30. Out of town counsel may attend by telephone. So we got a couple of people that's appearing from out of town, probably some California lawyers, in order to kind of push these cases that are familiar in California land that are not necessarily as familiar in Illinois. So they are saying that they're not stopping discovery. So discovery needs to be going on even while we're pending these motions to strike and dismiss. So you can't delay. The court is basically saying you can't delay trying to discover your information while we pin the determination of the motion to strike. Okay. And then we have the court saying I cannot get my life together right now. Mary Rowland also made a minute order saying individuals have been sending emails to the court staff. They should understand that the court only considers information that is submitted by the parties on the court docket. Materials submitted via email are not considered or stored. That is because it is not made part of the public record and the parties have not had an opportunity to respond to it. That material is summarily deleted. Now, as an attorney, which I'm sure all of these people representing them are attorneys, why would you email information to the court? Do you do that in your own court? I know there's some out-of-town counsels, some out-of-town attorneys. Why are you emailing things to the court? It's completely inappropriate. It's inappropriate. File your motion. File your document. You don't get personal contact, personal ex parte communications with the court. That's not how this works. So I thought that was funny. How the heck are you going to be emailing stuff and not having the other party see it? Improper ex parte communications with the court is basically what the court is saying. And then they're reminded not to record the court proceedings for the people that are appearing remotely. So I thought that was funny. But let's go ahead and jump into the chat to see what the chat has to say about this. Come on, boss. Okay, let's see what the chat has to say. We got Cheryl C saying Vasquez, not Vasquez, is the most common pronunciation. I'm gonna keep messing it up every time I mess it up. We have someone in the chat that has the same or similarly spelled last name, and I interchange it. So I try my best. Thank you, Cheryl C. Deacon Fatal, thank you again for the $5 super chat saying, is Jeanette miss? No, that joke won't work here. I still think she is nasty. Are you talking about Jeanette Braun? John Smith says, God, so many parties. What parties? Oh, the parties to the case. I'm like, what parties are going on, man? Tiny D says, how old is this childish entitled adult for this case? I don't know. John Smith says, don't forget they also want to silence anyone connected to the defense in any way, which blew my mind. No wonder they amended. Yeah, they do. They don't want people to say anything bad about them. But the thing is that you've come on the internet and put your face there and you're doing things. People are going to say bad things about you. People probably say bad things about me. They're probably like, that girl can't even read. Why is she on the internet reading every day? You gotta laugh at yourself. But like I said, you get on the internet, people are going to talk about you. And hopefully you find some people that like you, but there's going to be some people that talk about you. Deacon Fatal says, goodness. Deacon Fatal, thank you again for this $5 super chat saying, questions, are all entertainment lawyers this spicy? I feel like, I said, I don't know, but I'm going to lean more towards yes. I don't know if they all are, but I'm leaning more towards yes. John Smith, and again, thank you for the super chat. John Smith says, I suspect the defense that received the cease and desist and the DMCA requests are going to point out they were in fact fraudulent. And it's not necessarily that they're fraudulent, right? She could file it and believe that they're true. However, the system in which they check these DMCA notices, and I mean, I guess the cease and desist letter was not fraudulent. Janet, I didn't mix the name together. Janet has admitted that was her letter and it should not have been disclosed for other people to see. There's nothing stopping you from disclosing a cease and desist letter, okay? So that one wasn't fraudulent. Was it poorly written in bad attorney language and all of the things? Yes, it was a bad cease and desist letter, but it was not fraudulent. Janet said she wrote that cease and desist letter. She took full responsibility for that. For the DMCA notice, it's just really easy. Like, I'm thinking, and I don't know for sure, but I believe that the DMCA takedowns are like generated or reviewed by a robot. And as long as they use the proper language, they're going to take it down. I could be wrong. I could just suck at appealing them, but no, I haven't had to appeal many. But anyways, I don't think they're necessary. Well, I guess it's fraudulent if you know that you don't really qualify for a copyright strike or a copyright takedown. So yeah, I guess, I did all of that to just say, yeah, they probably are fraudulent. But the cease and desist letter is not. She wrote that letter, okay? She did write that letter. Small says, let me see. Oh gosh, what happened? Okay, Tanya D says, what is the chat goal today? Our like goal is 75. Oh my gosh. Y'all, the like goal for the stream was 75 likes. We are at 69 likes already. Shout out to the BriHive. Shout out to y'all. Like, how did we get here? Anyways, if you have not hit the like button, please do. It does help out the algorithm, helps us get more friends. And I don't know if you guys have noticed lately, but we have had more friends in the live streams and we have been loving it. Good chats going on, good conversation, good vibes. We love that for us. But if you haven't hit the like button, and I know some people have not, there are 64 people watching live, and I know people come in and out. Go ahead and hit the like button. We are 5 likes away from our goal here. Okay, let's see. Thank you, Tanya, for asking that question. John Smith says they are so stubborn. They are. They're not going to drop this. They are not going to drop this. John Smith says the plaintiff's lawyer is also making a name for himself in internet beef rounds. Really? I haven't been paying attention to that part of it. Kimmy is the one that really keeps me updated that there's new stuff going on. Small says, this is your friendly reminder to hit the like button if you haven't already. Finesse the algorithm. Thank you very much for that reminder. Yes, of course. If you haven't hit the like button, please do. I always forget to ask. And if you're not subscribed, if you're not subscribed, please do subscribe. Okay? Thank you. John Smith says John Avenatti was an entertainment lawyer too. I don't know who that is off the top of my head. John Smith says the judge is going to be so pissed off at the first hearing. If it goes there, it's going to go there. It's going to go there. They have a hearing on the 17th. It's a in-person status hearing, so it's not going to be much going on there other than, we're going forward and we're filing motions to dismiss and strike. And maybe or maybe not, we need additional time because what was the date? They had until the 22nd to comply. So they could ask for more time, whatever it may be, and they should be prepared to set discovery deadlines on the 17th hearing, the April 17th hearing. So there's that as well, y'all. So it's going to go to some hearings. Now, is it going to be substantive hearings? Maybe not. No, it's going to go through those. I don't think they're going to drop these claims. Like, I cannot see it. Shout out to Deacon Fatal. I see those memberships coming in. Thank you very much. Again, Deacon Fatal. I will preserve your ears and not do the horn. Definitely appreciate it. Thank you for supporting the stream so much. I definitely appreciate that. Welcome to all the new members that are going to be on the members live stream. I know you're going to be there. I know you're going to be on the members live stream. We have to figure out what cases we're going to cover, but nonetheless, we just got 20 new members. Shout out to Deacon Fatal. Thank you. Definitely appreciate that. Let's see. Kimmy Locker says to John Smith, they got a status hearing on April 17th. Yes, that is correct. John Smith says everyone involved is loving the publicity except Lauren the Mortician and Jeanette Braun. No, I think they like the publicity. I just think they are not getting the positive. They probably thought everyone was going to be behind them and supportive of them. I think they're more upset that it's backfiring on them, right? John Smith says, though I suspect that they're getting super angry about the legal bills piling up to defend against this. Yeah, agreed. So you're saying like the defendants are liking the exposure, plaintiffs maybe not so much liking the backlash. That's what I'm getting at. Kimmy says to John, fortunately, they had a successful GoFundMe campaign for legal fees, but I'd still be pissed, and it's just gonna keep going up. It's gonna be expensive. That was weird. Did y'all see the water fall out of that? I'm saying it's weird. No, you're being greedy and drinking your water all wild on the live stream. That's why water is shooting out of your bottle. The legal fees are gonna keep going up. So even with the GoFundMe, like, I mean, with them all combined, maybe they do have enough fees, but geez Louise, it's gonna be a lot. John Smith says suspect expect a lot of stipulation to fact. No, I don't think there's gonna be a lot of stipulation to fact, because Jeanette Braun and Lauren the Mortician can't even properly tell us what was said in the video. They're claiming she called me transphobic, and there's nowhere in there that says she was transphobic. So they had to come back and say, well, actually, she said I like transphobic content. Okay. How is that defamation? Okay. So I don't think there's going to be a lot of stipulation to fact. What do y'all think in the chat? Mary Jane, really not Sarah, another member of the channel, saying, what Game of Thrones now? I haven't followed Braun in ages. Yeah, it's been a while since we've touched on the case. I think like last month, but I mean, I guess that's not that too long. But yeah, there's a Game of Thrones case that I'm lollygagging on. So let me speed up the the chat, not the chat here, but speed up my talking here, because I'm just blah, 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 blah. We got another case in between the Game of Thrones ones, and the Game of Thrones ones is really long. So let me get through this. John Smith says all the defendants should ask for $75,000 to their own pockets to settle plus fees. Oh, they're definitely not settling if that's the request. Deacon Fatal says, I beg your pardons. Yeah. Deacon Fatal says Zoom for which one? For the attorneys to come on. They can do it by telephone. Mary Jane says, this thing seems like a sprawling mess. Lauren and Braun are just all over the place. I can't figure this out. I think a lot of the claims are going to be dismissed on the motion to dismiss for failure to state a claim. That's my opinion about it. Carolyn Lower says, is the attorney emailing the court, or is the people randomly sending the court emails? It says individuals have been sending emails to court staff. I'm assuming that it's the parties, but that's a good point, Carolyn. It could just be fans of the TikTokers. That would be interesting. The court's like, y'all need to tell your fans to check. Tell your fans to stop sending stuff to the court. I wonder if they do mean the fans, because it just says individuals. It doesn't say parties have been. The court only considers information that is submitted by the parties on the court docket. I automatically assumed it was the attorneys being dumb and sending emails directly to the court instead of filing their paperwork properly. But I think that's a good point. It probably is just regular people emailing the court, probably talking mess about Braun and Lauren the Mortician. John Smith says, I bet the discovery requests are going to be ridiculously onerous too, like surrender all electronic devices for inspection. Yeah. I can see that being a request from the plaintiffs for sure. Phoenix Waller says, John Smith, oh, I bet Janet and Lauren are menaces already just for filing. They probably want to remain nuances. And the thing about it, guys, it's like, what's it called? The Streisand effect. No one would have even been worried about it. No one would have known about it. Now you have multiple YouTube channels covering this. Okay? You have multiple YouTube channels covering this. It would have died off by now. Definitely would have died off by now. But to each their own. To each their own. We got Deacon Fatal with another super chat. Thank you very much, saying Skippity Paps. I don't know what that means. But thank you very much for the super chat. I don't know what that means. Skippity Paps. Is that something I should know? Lady Drakeness says, let's give them something to talk about then. We are, especially when Runkle and I attack this thing. Kimmy Locker says, 69 likes. Yeah. 69. Sorry. I did not catch that, but y'all did. Shout out to y'all. I think we hit our like goal now, but let me get through the chats. Deacon Fatal, again, thank you for the 20 gifted Boss Attorney Bree membership. Appreciate that. Much appreciation. Welcome to all the members. Mary Jane, not Sarah, really not Sarah, says, laughing my A off. Are y'all really laughing at the 69? I didn't even catch that. Kimmy Lucker says, we're a mature chat. Yeah, you guys are very, very mature, okay? I didn't even catch that. Grow up. You guys are silly. Mary Malarkey says, I remember celebrity lawyer Mark I'm gonna say that wrong. Geragos. He wasn't spicy, but he was always on TV and being quoted and seemed like he represented everyone in Hollywood. And Gloria Allred too. Yeah, I'm not too familiar with them. Mary Jane says, I always hit the like for you, Bree. I'm so happy to be home watching my streams. Well, we are happy to have you here in the live stream. Happy to have you back. And we appreciate the hit to the like button. Love that for us. Kimberly Rudd says, this suit makes me laugh. Thank you for the update. Small update, but update nonetheless. Let's see where it goes. Hopefully these motions to dismiss and strike gets filed soon and ruled on soon so we can know a little bit more. Deacon Fatal says, this will be the last one I will be able to do in a while because I am too poor to worry about rich folks' issues. I understand. But we like talking about it, okay? Deacon Fatal says, thank you for your consideration for my ear. You are welcome. Deacon Fatal says, they are just messy. The whole case is a mess, right? Lady Draken says, I pass no judgment on the drinking game. Which drinking game? Deacon Fatal says, water is good. I like water. This is water, but it's like jumping out of my bottle here. Mary Milwaukee says, first goal reach. Okay, we're there. Let me finish up the chats. I'm almost done. Mary Jane says, I'm drinking Jägermeister. Normally wouldn't know how to say that, but I think that one was right. I should have brought the whole liter of it. No. We don't need to get that lit on Thursday. Small says she literally was shown like in transphobic context. She made someone expose her / revealed the truth. The thing is, I mean, if you're doing it, you're doing it. Like she's gonna say, yeah, I like that, but that was not transphobic content. But who is going to be the judge of what is and what's not transphobic? Are there transphobic experts out there? I don't think so. Like, how are you going to determine what's transphobic and what's not? But let's see here. Small says, this was what Deeks was referencing, Bree. Okay. I can't click the link, but maybe I'll check it out in a minute. Let's see. Ohio Palm Mom says, I love that everyone calls her Janet because she said it makes her mad. Yeah, everyone, matureness is what's on the internet. Remember that. John Smith says, Gloria Allred is still a thing, but her gig was representing women against powerful men. Yeah, that's a good thing to do. Sorry to the men in the chat. Mary Jane says, LOL, drinking games are good. I was thinking about doing like stream bingo, not to drink though, y'all. But I guess if you want to, I'm not the boss of you. But I was thinking about doing stream bingo where we have one bingo card and we kind of mark them off as we go through the words on the stream. Kimmy Locker says, I sent the link in private chat. Okay, perfect. Let's see. Your water drinking game is what I was referring to. I wasn't drinking. It wasn't a game. It was just me drinking bad. Y'all are silly. Okay, let me see what y'all are talking about. Okay, let's see. Let's go here. And then we are going to unshare our screen and then we're going to share. Can I show this on live stream, y'all? Because I'm just trusting the chat. I'm trusting the chat that I can play this on live stream. So let me see here. Wait a minute. It looks long though. Oh, that's okay. It's the Skippity Pap thing. Okay. Let me learn how to share my screen here with the volume. Okay. Here we go. I'm looking at you. What you about to do? Can y'all hear that? Could y'all hear that? Let me know. Let me know. Small saying it's safe. Let me play it again and tell me if y'all can in the chat.
Straight to Skippity Pap. Oh, what's that? Skippity Pap. Stop staring at me.
Can y'all hear that? I'm waiting. Okay, Kimmy is saying yes, they can hear it. I know there's a little bit of a delay on the live stream, so okay, let me get it together. Let's watch Skippity Pap.
I'm looking at you. What you about to do? Well, I was going to demonstrate the Skippity Pap. Oh, what's that? Skippity Pap. Stop staring at me. What's going on here? Y'all ain't just gonna be walking through here like y'all. Oh, yo, who is this coming through? You get the double Skippity Paps, man. One for each.
Are y'all saying to do that?
Y'all better start getting
Jeanette
clearance out here before you just walk, because you can get the. Oh, you can,
to the
double up on the Skippity Paps, man. I got Skippity Paps all day, man. Y'all, you bet. Oh, look off me, man. Get your filthy nail clipping hands off me, man. Pedicures is for pussy cats, and the butcher knife of paralysis that was forged by Odin himself. Oh,
y'all got me off
you
of
real piece of
topic.
Work. When I get out of here, you're finished. Ew, how can you eat that, Rondell? Shut it up, Talbot.
Oh, is this the end of Skippity Pap?
People out here enjoying their life, doing what they love.
Get our lives together, y'all. We got 2 more cases to cover, and we are an hour in. But thank you for sharing the link to the Skippity Pap. Thank you for informing me and educating me on Skippity Paps, guys. Thank you, thank you. Kimmy Lockett says that's what Deacon Fatal thought of when she heard anti-slap. Yeah. Makes sense. So Katoa says, I'm game for stream bingo. Okay. That's more work. And I barely got it together now, but that's okay. We'll do it. We'll try to use words where they're common to the stream and then words that pertain to the lawsuits that we're covering. So we'll try that. Carolyn Lower says, comes now would be the free space. Love that. Our Alexis Carney says, I have a bingo game for TikTok mock trial. Think Karen's court. And the free space is lack of jurisdiction. That's a good one. Kimmy Lockett says, I can make a community post for people to suggest bingo squares. Yeah, that would be fun. And maybe we'll do it like for the week and then just make bingo cards for each stream. So, and we could potentially just share them so that you guys can do your own bingo card. Look, I'm getting too fancy. We could share the bingo cards so we can see who wins bingo. I don't know what prize. I'm never good at the prizes though. Maybe it's just fun. Right? Okay. We done Skippity Papped. We done talked about Lauren the Mortician and Jeanette Braun's lawsuit. Now we need to dive into the Bravo lawsuit. This one, we are going to be going through the facts of Bravo, not the facts, but the kind of intro of Bravo responding to the Manzo lawsuit. And then we're going to go through the headlines. We're not going to read all the way through it because it's a lot of pages and some of it is not relevant anymore because Manzo did go ahead and file an amended complaint, just like we kind of talked about in, let me go ahead and swoop actually, and then we'll get into that. Okay, so we're going into the Manzo versus Bravo's lawsuit. We're not going to go in too deep into the motion to dismiss because Manzo has filed an amended complaint. So some of the motion to dismiss is not going to apply to the new amended complaint, just like in Jeanette Braun and Lauren the Mortician. They filed an amended complaint, and now the defendants have to file new motions to dismiss and new answers to the actual complaint. So we're just going to kind of skim through it to see how spicy Bravo is being, and then we're going to jump into the case of the day, which is Joseph Gatt from Game of Thrones being sued for suing someone for falsely accusing, or suing the DA for falsely accusing him of being inappropriate with children, which is bad. But hopefully we'll be deep enough into the stream to where YouTube doesn't get mad at me. Okay. Anyways, let's go ahead and figure out how to reshare my screen. Okay. Being professional here. All right, there we go. Wrong case though. Let's see. Manzo, motion to dismiss. That's what we want. Let's jump into it. For those of you that don't remember this case, Manzo is a Real Housewife of New Jersey housewife cast member. She joined the Ultimate Girls Trip on Bravo, and she is accusing Bravo of basically creating an environment that caused her to be SA'd by another cast member, Brandi Glanville. She's basically saying that Brandi groped her, she locked her in the bathroom, she was being all sexual with her, and she didn't want it. She grabs her boobs, all kinds of stuff is what she's alleging, and she's blaming Bravo. She didn't even name Brandi in the lawsuit. They're just like, Bravo, you are responsible for what Brandi does because you know Brandi has been doing this for years. Bravo's like, no. So we're going to go through the motion to dismiss, but remember, an amended complaint has been filed. So if y'all do want to cover that on the next live stream, make sure you go ahead and comment it and let me know that you want to cover it. Otherwise, the amended complaint goes bye-bye, okay? It goes bye-bye, but we don't want it to go bye-bye because Kimmy highlighted the differences for us. So we probably are still going to cover it whether you guys want it or not, okay? So we got Caroline Manzo suing Bravo Media, Warner Bros. Entertainment, NBCU Universal. And we have, this is a memorandum of law in support of the defendant's motion to dismiss the complaint, not dismiss sections. They said dismiss the whole goddamn complaint, okay? Because she's wrong. She's not pleading actual things that she can plead, okay? So let's go ahead and scroll down to the next part. Sorry if this is making y'all dizzy, but they got long tables of contents. Let's see here. Preliminary statement. The Real Housewives Ultimate Girls Trip is a reality TV series, part of the enormous, popular, and long-running The Real Housewives franchise. Each season of Real Housewives Ultimate Girls Trip features a group of extroverted women who appeared on prior seasons of various Real Housewives shows as they vacation and socialize together. The franchise is widely known to include provocative content. So, you're saying that the content is provocative. I don't think that really goes in your best interest because she's basically claiming that y'all promote this nonsense. Remember, like Rachel Levis's complaint, Bravo does this. I don't know if that was the best thing to say, but let's go on. Plaintiff is a reality television personality between 2009 and 2014. She was a cast member on The Real Housewives for New Jersey. In 2023, plaintiff entered into a talent agreement under which, in exchange for a substantial fee, she got paid dollars, okay? Plaintiff would appear as a cast member in what was expected to be Ultimate Girls Trip Season 4 to be filmed on Morocco. At the time, 3 seasons of Ultimate Girls Trip have been exhibited. Plaintiff alleges that one of her castmates, Brandi Glanville, harassed her in Morocco during filming of the show on January 24, 2023. Rather than sue Glanville, plaintiff asserts 18 causes of action against defendants attempting to invoke state and federal laws under a wide range of legal theories, including trafficking. Plaintiff's claims must be dismissed on multiple independent procedural and jurisdictional grounds. Plaintiff claims also fell on the merits, both as a matter of law under New York Broad's anti-SLAPP law, which requires her to proffer sufficient factual support to establish a probability of success on her claim. So we are now skippity papping again, but this time in New York, not in Illinois. First, plaintiff's New York State. Well, sorry. I'm like, what? First, plaintiff New York State and City Human Rights Law, California Fair Employment and Housing Act, and New Jersey law against discrimination claims are jurisdictionally barred. Plaintiff alleges discrimination and injuries in Morocco and has not established the requisite state nexus to invoke the state statute. So remember, she's saying that she was assaulted in Morocco, and she's trying to use United States claims. You have to basically invoke and explain to the court why these laws should apply in Morocco when the the occurrences did not happen in the United States. So they're saying bars claims 1 through 6, 9, and 12 through 16. Second, plaintiff intentional infliction of emotional distress and actual battery claims are barred by the 1-year statute of limitation for intentional torts. Because her negligent infliction of emotional distress claims are based on allegedly intentional conduct, they are likewise time barred, notwithstanding their titles. So they're basically arguing that she is trying to claim intentional infliction of emotional distress, but also negligent, but the conduct is actually intentional. So the negligent claim should also be barred because whatever conduct she's alleging was actually, in fact, intentional. So you can't then go, oh, well, negligent is a lower standard, so I should be able to assert this to overcome the 1 year statute of limitation, which it does seem like she waited longer than a year to bring these claims. Third, the negligence-based claims are barred by workers' compensation exclusivity. So they're saying, sue us for workers' compensation issues. Don't come and sue us in a lawsuit. Or not sue us under workers' compensation, but file a workers' compensation claim. Fourth, plaintiff's contractual release bars her or intentional infliction of emotional distress and negligent-based claims. Basically, she signed a contract that says, I won't sue you. This is where a lot of the Bravo lawsuits are coming in and calling their provisions unconscionable and that they shouldn't be enforced because it stops people from bringing claims that are important, basically silencing people. You can't just say, I waive my right to not be unalived on this show. So then if you become unalived on Bravo can't then say to your family, no wrongful death because she signed away her rights to be unalived. Hands up, Bravo's hands are up. So this is where we're going to get into some of that argument of, well, that provision of me saying I would never sue you for anything ever, that's unconscionable. I have to be able to sue you if you harm me. So there's that. Fifth, plaintiff's federal trafficking victims protection claim is jurisdictionally barred because that statute does not permit civil actions concerning injuries incurred outside of the United States. In any event, to prevail under the TVPA, plaintiff must show that defendants knew that plaintiff would be forced to engage in a commercial sex act as a matter of law. Plaintiff fails to establish anything close to the forced sexual labor the TVPA is intended to combat. So they're claiming that Bravo knew this was going to happen and basically they set her up for it. Bravo is like, how are we supposed to know what that lady was going to do? Okay. Manzo is saying you knew what she was going to do because she's done it to other people before. She's been inappropriate with other people before on the show. Don't know how far that's going to go. 6 says plaintiff's sexual harassment, discrimination, and retaliation claims under federal Title 7. She failed to allege any adverse employment action, let alone because of her sex. Even if not procedurally barred, these same failures bar plaintiff's state statutory claims. So you can't allege, what was this one? Adverse employment, because Bravo's going to go on to say she never lost her job. She was paid and she voluntarily left. Even if plaintiff complaint would survive a motion to dismiss scrutiny, it should nonetheless be dismissed under New York anti-SLAPP law. Under that law, claims related to conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest are subject to a heightened standard. They're making a TV show, so they have that anti-SLAPP free speech protection going on here. Here, all of plaintiff claims are based on allegation of defendants' actions taken in furtherance of free speech, the casting, directing, and production of a television show. Therefore, the burden shifts to plaintiff to demonstrate that her claims have a substantial basis in law by producing relevant proof to support her claims. Plaintiff falls far short of that. Factual background. Let's get into some more juicy things. Oh, you guys know what? I said I was going to stop. I was just going and going and going and going. Let me see. We have very much so surpassed our like goal for the stream. Completely forgot to say that before we jumped into this case. We are at 88 likes. We got 66 people watching live. Shout out to the BriHive. Love to see that. Okay, welcome in. Thank you for supporting the channel. But we hit our like goal. So you know what that means. We're going to play our like goal animation. However, we do have a warning still going on because I have not been able to fix the volume still. We're super proud that we hit our like goal, but there is a very loud explosion at the beginning of the like goal. So this is now your notice to turn down your volume if you are sensitive to loud sound. So 3, 2, 1, we're going to play it. We exploded our like goal. Shout out to the BriHive. We love that for us. We really love that for us. Uh-oh. It just kept going and going and going. But thank you very much, y'all, for reaching the like goal. We set it at 75, but I really think we're going to get past 100 this live stream. I know we are going to get past 100 now. Like, you guys exceed my expectations every time I live stream. Every time I live stream, I swear to you. Okay, let's jump back into the lawsuit. I'm sorry for that brief intermission, but I completely forgot to celebrate our like goal, reaching our like goal. Okay, let's get back into it. Factual background: plaintiff agrees to be featured on the Ultimate Girls Trip Morocco. Plaintiff is a New Jersey resident between 2009 and 2017, or 2000. Where do you see a 17, Brie? That says 14. 2014, she was a cast member on New Jersey Housewives. In December 2022, she signed the talent agreement in exchange for substantial compensation. What is the compensation? Why do you keep saying substantial? I want to know how much she was paid. You know, some of them get paid like over $30,000 an episode. Some of them get paid like $80,000 an episode. I'll be mad if I was the one only getting like $5,000 an episode. That's crazy. But anyways, she got substantial compensation, right? She's also the one that says that she needs this job. Excuse me. She needed this job to take care of her kids, right? So substantial compensation is what they're referring to it as. Plaintiff agreed to participate in the Ultimate Girls Trip Morocco. Plaintiff agreed that defendants had the right to record her at all times during production and that actions and depictions of plaintiff and other cast members would be deemed part of the work. She acknowledged that she may encounter speech or physical contact that she may consider offensive, including from other cast members, and assumed all risks associated with the show. Now, this is like a boilerplate thing that these TV shows put into contracts. I'm wondering if this is going to be the moment where they start invalidating these provisions in lawsuits. Remember in the Love is Blind contract that we covered, there was like, if you get an STD, that's your problem. Like, you're consenting to that basically from being on the show. I'm thinking everyone gets tested before they start the show. Like, is that not part of it? Or you just assume the risk like they're saying here? So there is that. Let me go ahead and jump further down. I'm uncomfortable sitting here. In addition, plaintiff irrevocably and unconditionally released defendants to the maximum extent permitted by law for all claims relating to the Ultimate Girls Trip Morocco on any legal theory, including negligence and infliction of emotional distress. This release applied to unknown and unsuspected future occurrences and claims. Again, this is going to be one of those things where the issue is going to be, is this provision too broad that it makes it unenforceable, unconscionable? Is this lawsuit, are these Bravo lawsuits going to be where we can kind of overturn these provisions? Okay, plaintiff participates in Ultimate Girls Trip Morocco. Plaintiff alleges that during filming in Morocco on January 24, 2023, in the presence of the 5 other main Ultimate Girls Trip cast members, Glanville kissed and mounted plaintiff without consent. Plaintiff alleges that later that evening, she went into a bathroom with Glanville and 2 other cast members, including Alex McCord, a support to Manzo and a licensed therapist. And Glanville groped plaintiff. She alleged that producers went to the bathroom door, but the door was locked from the inside. She alleges that later that evening during filming, Glanville massaged plaintiff's boobs. Oh, I guess breast is a scientific term. Okay. Over clothing in front of the cast and made sexual comments to a male production crew member. Plaintiff alleges that she was in a state of shock during these events as a result of having been SA'd as a child. She further alleges that the 2 senior producers visited her that night to understand what had transpired. She explained her experience and requested not to be left alone with Glanville. Glanville and plaintiff were not left alone thereafter. On January 25, Glanville was separated entirely from the cast and had no further interaction with Manzo. On January 28, plaintiff voluntarily left the production earlier. Despite choosing to leave filming early, plaintiff was paid in full under her talent agreement and does not allege that she was terminated or denied any pay. And so that's highlighting that provision or that claim that she was retaliated against because of her sex. Because she left the show early, but Bravo still paid her the full amount, which was kind of covering Bravo's butt at that point, right? So let me just stop here and say thank you to Z Seltzer for a super sticker. Love that. Thank you. Oh, thank you for supporting the channel. Definitely appreciate it. If you guys look in the chat, StreamYard doesn't show it, but in the chat, we got a little cheerleading. Is that like an apple? What is that? It's a cheerleading fruit, but thank you very much for the $3 super chat. Definitely appreciate it and happy to have you here live. Let's jump back into the case. We got some legal standard. I don't know what this is off the top of my head, so I'm going to read it. Under CPLR 3211A, dismissal is warranted if plaintiff fails to assert facts to support the element of the claim. So it's basically a 12B6 motion, but under under New York law. So that makes sense. So she failed to state a claim. And let's talk about why she's failing to state a claim. Plaintiff's state statutory claims are jurisdictionally barred. We talked about that earlier. All of this took place in Morocco. How does the United States law attach to these issues? Plaintiff fails to allege an impact in New York. Claims by a non-resident for alleged violations of those particular statutes. Violations must be dismissed unless the alleged discriminatory conduct had an impact on plaintiff within New York. A decision by an employer located in New York to take an adverse employment action against a non-resident working outside of New York does not satisfy the requirement. So there's that. We're not going to go through it. Remember, we're just reading the headlines on this one for the most part because we got to get into that other long case. Plaintiff fails to allege a California nexus. Remember, the defendant is a New York resident and plaintiff is a New Jersey resident, but she's claiming some protections under California law. How is this applying here is what they're asking. Plaintiff fails to allege a New Jersey nexus. Again, the incidences happen in Morocco. Although she is a resident, she can't apply that law. Plaintiff tort claims are time barred. We talked about that earlier. She waited more than a year. She alleged that she was injured on January 24th, and she filed the complaint on January 26th the next year. So off by 2 days, and they caught that, and we'll see what the court says about whether that's too close in time or if the allegations actually occurred a few days later. That's going to be an interesting fight right there. A 2-day difference. And I believe the 24th was the actual first incident, not the end in her leaving, right? So that's going to be an interesting one to see how they decide on that. Plaintiff's IIED negligence and NIED claims are barred by contractual releases. Remember, I cannot sue you for any which kind of way. Release of future unknown claims, which are commonly used in the entertainment industry, are enforceable and should not be lightly set aside. So they're saying these provisions have already been approved by other case law. Courts applying New York law recognize the commonly known fact that individuals who choose to be featured on reality shows, see, I didn't know this. I'm glad I stopped to read this part. On reality shows generally accept the risk that they will be subject to behavior that may be outlandish or provocative. That's a 2013 case. And regularly dismiss claims by reality television participants pursuant to such releases. That's a 2018 case. Then we have pre-film and release bars plaintiff from asserting any claims related to her participation on the program. That's an intense provision. Wow, they're bound by the agreement. I thought this was going to be something new, but no, I'm wrong. I don't think this is going to be case law that's turned over. Plaintiff's negligence and NIED claims are barred by workers' compensation. Plaintiff negligence-based claims are also barred because workers' compensation is the exclusive remedy for an employee injured by negligence or wrong of another in the same employee. So you have to make a workers' compensation claim. Plaintiff's federal Ex trafficking claim must be dismissed. Criminal liability may be established for whoever knowingly recruits a person or benefits financially from participating in a venture, knowing or recklessly disregarding the threats of force, fraud, or coercion will be used to cause the person to engage in a commercial sex act. Victims may bring civil actions against the perpetrator or whoever knowingly benefits from participation in. Bravo is basically like, we're not the perpetrator, nor did we benefit from this. TVP does not grant extraterritorial application, must be in the States. Let's see here. Plaintiff fails to plead any forced commercial sex act. The Commercial Sex Act is defined as any sex act on account of which anything of value is given or received by any person. Plaintiff fails to satisfy any of that element. So she's saying that she was assaulted, basically, but is the assault considered a sex act, right? And then also the other question is, did Bravo benefit from it? Did Brandi give Bravo money for letting her touch Manzo? You could argue that, yeah, I mean, you guys made money off the TV show, but I think that is going to be a little bit of a stretch there. So I got weird words on the screen, so let me go ahead and scroll down. Plaintiff fails to plausibly allege that defendants had notice. Basically, they didn't have noticed that Brandi was an issue, and when they found out, they made sure that Brandi stayed away from her. Plaintiff fails to plead unlawful harassment / discrimination or retaliation. I think that one's self-explanatory. Let's go through it. And that was a long one, so maybe it wasn't self-explanatory. Plaintiff's complaint is an improper group pleading. Plaintiff claims also fail because they are not sufficiently particular to each defendant. A complaint that lacks any specification as to the precise tortious conduct charged to any particular defendant must be dismissed. I think that one's a little hard to overcome because they're all like the production company, but depending on what hand each production company had into things, maybe that's where she could become more specific. Plaintiff complaint must be dismissed under New York's anti-SLAPP. As discussed above, plaintiff complaint fails under the 3211A standard. Even if the court disagrees, it must still be dismissed. The complaint must still be dismissed under a more stringent standard of 3211G and the New York anti-SLAPP statute. Plaintiff complaint attacks defendants' alleged actions in furtherance of creation of a popular television series, including the casting and on-camera performances that were part of its production, and thereby seeks to stifle defendants' free speech. Remember, we had similar claims to this in the Lizzo lawsuit. So I think they're going to be able to succeed on anti-SLAPP on a lot of this. This is an action involving public petition and participation. They're on a reality TV show and the public watches it. Plaintiff claims arise from conduct in furtherance of defendant's free speech right. They picked the cast, they put the trip together. They didn't necessarily tell them to do the things, but they are able to pick who they want on the show to bring as much drama as possible, right? Let's see here. Ultimate Girl Trip involves matter of public interest. People watch the show. Plaintiff cannot demonstrate a substantial basis of law. Because the first prong of anti-SLAPP statute is satisfied, plaintiff bears the burden of demonstrating a substantial basis for her claims under the heightened standard of proof. As set forth above, plaintiff failed to adequately allege any claim and therefore necessarily cannot show a substantial basis. But even if her pleadings were deemed sufficient, she would be required in opposing this motion to produce such relevant proof as a reasonable mind may accept and as adequate to support a conclusion of the ultimate fact. She cannot, for all the reasons discussed above. Okay. That was hard to read. Okay. And then defendants are entitled to attorney's fees. Y'all basically made me respond to this. So give me some money. Is basically what they're saying. Like I said before we got deep into this, all of this may not apply moving forward because there has been an amended complaint that we will cover on a different live stream. And hopefully it's not 3, 4, 5, 6, 7. No, you can only do 3. 3 amended complaints. Hopefully this is the first amendment and that's it. And they can move on to everything else. Hopefully there's no more amendments needed. So if you guys have comments on this lawsuit, let me know what you think. Go ahead and drop it in the chat. We're going to be looking at what the people have to say. And then we'll jump on to our Game of Thrones lawsuit now. Am I going to be able to get through Game of Thrones? I already cannot read, and we got a whole case to go through, but we will see where we go from there. So let me just get Bossy B in here. All right, let's see what we got. We got John Smith saying, I think I've heard of this, the Manzo case. John Smith says, I want to see the releases in the NDA from Bravo. Me too. Me too. Kimmy also told me that they provided a video of the alleged incident, if I'm not mistaken. That's blocked. We cannot see that quite yet. Sokotoa says, extroverted is putting it mildly, right? As far as the personalities of the people that get on the show. Island says, I still have questions about whether they're really employees at all. I think under Bravo, I think they do hire them under employment contracts. So generally that's not really contested. They're not going to argue that they were independent contractors when Bravo hired them as employees. So and even if they didn't hire them as employees, they may still have workers' compensation coverage for them. So I don't think that one, what did I do? Okay. I don't think that one is something that Bravo is going to be willing to waste their money arguing over, because I think they do hire them on as employees. Mary Malarkey says, Bravo lost, hashtag Bravo lawsuit. According to the complaint, Caroline Manzo was SA at age 7. Source Hollywood producer on January 26, 2024. Yeah, so they did mention that in this one that she was basically non-reactive because she was SA'd before, which could happen. It could be like a trauma response. Mary Jane says, LOL, Brie, you're saying that all weird are you? Yes. Yes, I am. I am trying to avoid it, but they probably still pick up on it. I'm avoiding YouTube censors. Yeah. Mary Jane says, actual. Yes. That's what I'm trying to do. I don't know if I'm doing a good job at it. John Smith says, these are good freaking lawyers. Yeah, they came with the sass for sure. I can agree with that. Thank you, Z Seltzer, again for the super sticker. Definitely appreciate it. John Smith says, right, but if it's illegal, it breaks the contract. Right. If it's illegal, I forget what the standard is. It has to be like pretty much criminal, right? For it to break the what is it? The contract. Can't even think right now. But yeah. Kimmy Locker says to John Smith, yeah, one of the things the amended complaint addresses is the contract, and she asked for injunctive relief regarding it, among other things. Kimmy Locker also says the talent agreement was also filed as an exhibit, but it was filed under seal pending redaction. So I'm looking forward to seeing that, assuming it's not redacted to smithereens. Same. We need to see the Bravo agreement. Yes, we do. All the Happy Squirrel says, these reality TV contracts are wild. Who thinks any of this mess is a good idea? The people that go on the show and the people that watch it? The people that go on the show that don't have their lawyers review it and they just say, I want to be famous and want to be on TV. They think it's a good idea. Just sign it. A lot of these, remember when we covered the Love is Blind one? It was like DocuSign. And you know, DocuSign like fills in things automatically for you, so you don't actually have to read it. So there's that. Mary Malarkey says, Bravo lawsuit. The lawsuit aims to discourage defendants from continuing to sacrifice their cast members' safety for their own ratings and profits. Good luck with that. Yeah, no, they're still making these they're still making these cases. Okay, they are still making these cases. So I'm not these cases, these shows. So it's not really going to help them here, okay? Mary Jane says, we love the BriHive. Yes, dropping the emojis, the membership emojis. Love that, although StreamYard doesn't show it to us still. JC says, I've never heard that Brandi ever did anything like this to anyone. She is a bit promiscuous. She does say like inappropriate things. She grabs people's butts. She says like, you want it. She does stuff. And it's in the complaint, and they show pictures of her doing the stuff and making people feel uncomfortable. So she does stuff. I have to say that. John Smith says, this is more complicated than I had expected. Yeah, it is. Mary Jane says, I am ADHD. My ADHD is going wild. My friend applied to a reality show, but I'm glad she wasn't chosen because those people are miserable. And the thing is, this is like boilerplate, be on a reality show contract, right? I'm sure Bravos are a little bit more extensive, but still that you're signing something like this, if not exactly this, you're signing something like this in order to participate on these reality TV shows. Let's see. Sokatoa says, working on a Rubik's Cube while I listen. Love that. I haven't used a Rubik's Cube in so long. Mary Jane says, OMG, I never watched Game of Thrones. Me neither. Me neither. Mary Malarkey says, Bravo. I love how you're doing the Bravo lawsuit so we know what we're talking about. Mary Malarkey says, Manzo's attorney, Brandi Glanville, stated she was simply doing what the producers told her to do. Reality TV is leading to severe emotional and physical harm of its talent. This must stop. Oh, yeah, we did read the Brandi letter on this channel too a couple weeks ago. So I do remember her saying that. So that might implicate Bravo. All the Happiest Girl says to Mary Malarkey, that seems like a reasonable takeaway from what we've seen coming out of the Bravo Leb suits. And there's a bunch of them going on right now too. Kimmy Locker says, yep, they filed five unaired videos, but also filed a motion for them to be permanently sealed. Fingers crossed it's denied, but only time will tell. Yeah, do we want to see them though? Like, they probably wouldn't be appropriate to play on the internet, on YouTube, right? Mary Jane says, LOL, you're doing a good job. Thank you. And Mary Jane says, never sign. Don't sign the agreement. Mary Jane says, I went to hospital, signed nothing coming or going. Hey, that's good. They didn't force you. John Smith says, seems like it's Bravo bread and butter these days. This is what Bravo do. This is what they do. Sokatoa says, Game of Thrones is pretty good. Or, get it together. Game of Thrones is pretty good, or just YouTube the highlights. I just never got into it. I'm not saying it's a bad show or anything. I just never watched it. All the Happy Squirrel says, I love Game of Thrones until they passed the book storylines. Choices were made. Doesn't that always happen? They get too far, too deep into it, start doing their own things, right? Thank you for the chats, y'all. Y'all were interactive tonight. We're at 95 likes, y'all. I said we can pass 100 likes tonight. 5 more likes and we can pass 100 likes. Let's double our goal. Let's double our goal. Okay. If you haven't hit the like button, please do. It does help us out in the algae. Is that a cool word? Algae, the algorithm. It does help us out. If you haven't hit the like button, we would definitely appreciate it so that we can not necessarily double our like goal, but hit our second like goal for the stream. So let's go ahead and get Bossy B in here so we can go on to Game of Thrones. Okay, y'all, let's see if we can get through it. I said this was going to be a short stream in my head, but note to self, every time you plan on covering 3 cases, it's not going to be a short stream. Stop thinking that, Bree. It's just not going to happen. Okay, it's not going to happen. This one has some pictures in it, so maybe it might go a little faster than expected. But nonetheless, when I cover 3 cases, I cannot have a quick stream. Put that in your brain. Put it in your brain. Okay, chat. Is it in your brain? It's in my brain now. 3 cases, long stream. That's what it equals. Okay, let's go ahead and jump into Game of Thrones. Y'all, I don't have a summary for y'all because this is a blind react for me. Apparently, one of the actors from Game of Thrones is suing the DA of LA, if I'm not mistaken. Yes, in California, the DA of LA for basically falsely accusing him of being inappropriate with children. That's all I know. It looked like there was like some Snapchat messages exchanges going on. So that's all I know. It is Joseph Gatt. Am I saying that right for the Game of Thrones fans? Jason or Joseph Gatt or Gott? Is it Gatt or Gott? Either way, it goes. Let's jump into it. Did I already do Bossy the Bee? I think I did. She did come in here, right? Joseph Gatt is suing George Gascon, Los Angeles County, Angela Bronson. Bronson? We got Bronson and Braun. Or Brunson. Okay. A little different, but kind of the same. Danos, is it Dinos? Danos, Amarantos, the city of Los Angeles, and Does 1 through 10. He is suing under 42 USC 1983, violation of 4th and 14th Amendment, did not give him due process, and a violation of 42 USC 1983, Monell liability policy, practice, or custom. I don't know what that is off the top of my head, so we are going to be learning together. Introduction of the lawsuit. This lawsuit arises from, and sorry guys, trigger warning, it has to do with I know I mentioned it earlier, but I didn't give a trigger warning. It has to do with inappropriateness with children. So if you are sensitive to those type of topics, it is okay to sign off now. But nonetheless, we'll get into this. This lawsuit arises from the shocking and intentional destruction of Joseph Gatt's acting career and personal reputation by Los Angeles County law enforcement personnel that resulted from a thoroughly botched criminal investigation entirely lacking in any probable cause, led by an obviously conflicted deputy district attorney who sought to destroy Gatt based on nothing more than bias and personal animosity. Woo! That was a strong opening paragraph. Could I have read it more smoothly? Sure. But that was an intent. Like, those were some strong words used in that opening paragraph. Let's go ahead and check. He got some good lawyers. Whoever he hired, he did good. Okay, hopefully we don't get no typos. Defendants using threats, intimidation, and coercion, and with no cause, let alone probable cause, subjected Gatt, a successful actor with numerous film and television series credits, including Game of Thrones and Banshee, among many others, to an utterly baseless arrest, unlawful detention, unlawful search and seizure of property, and malicious prosecution in which Gatt was alleged to have electronically communicated with a minor in a actually explicit manner. Defendant's conduct was purportedly based solely on the uncorroborated word of a then 16-year-old, admittedly obsessed fan of Gatt, who will be referred to throughout this complaint as Jane Doe, to preserve her privacy because she was a minor at the time and is not a party to this action, who Gatt did not know and has never actually met, and whom defendants did not even bother to interview or even remotely assess for credibility until almost 1 year after. Defendants arrested Gatt, charged him with baseless crimes, and publicly branded him as a serial pedo. Can we say pedo on YouTube? Well, we did now. We're gonna call him a pedo. Or we're not gonna call him a pedo, but we're gonna use the pedo word. Okay, so wow. This attorney got some strong language skills, okay? That it's written so smoothly. Even if y'all hear me stumbling over words, it's not this attorney's fault, okay? This is pure butter and intensely. And at first I was like, I don't know if you're going to have like the no probable cause thing, blah, blah, blah. But when he said they didn't interview her for a year, I was like, oh yeah, no probable cause. No problem. You didn't get her to even say he did something. Whew. Okay. I'm thinking he was not going to win, but second paragraph, he changed my mind. Let's see. Even worse, Gatt was arrested I'm gonna say his name differently every time I'm learning. Gatt, he's y'all know who I'm talking about, okay? Even worse, Gatt was arrested and prosecuted based solely on unauthenticated pictures of social media conversations displayed on an unidentified phone screen that on their face was highly suspicious and facially untrustworthy. Indeed, even a cursory review of these photographs of an unidentified phone revealed that the supposed conversations were obviously fake, as they were replete with inconsistencies and conflicting statements that often made no sense whatsoever in context. Despite the clearly untrustworthy nature of these pictures, defendants made no attempt whatsoever to obtain and review a forensic image of the actual phone on which these supposed conversations allegedly took place, or to otherwise review any of Jane Doe's electronic or online data in an attempt to confirm or refute her story before maliciously and recklessly weaponizing her patently false allegations to destroy Gatt's reputation and career. In other words, defendants prosecuted Gatt for an electronic crime with utter disregard for the vast amount of electronic evidence that was readily available to them, and which would have definitely shown that the electronic communications on which the prosecution was based were entirely fabricated. Instead, DDA Brunson, who Gatt later learned already knew him at the time and held personal biases and animosity towards him. What did you do to this man? They're gonna tell us later. I saw the whole section of the animosity. So we're gonna get into it, okay? Simply ignored the glaring red flags that would have caused any reasonable person to recognize the complete absence of probable cause, and proceeded to have Gatt arrested, prosecuted, and publicly branded as a pedo. All without any iota of the electronic evidence needed to prosecute Gatt. Indeed, while defendants spent hours searching Gatt's computers and electronic devices in conjunction with his unlawful arrest, they found nothing incriminating whatsoever, took no digital image of his computer, and instead, during their search, seized an unremarkable purple blanket. Why y'all take this man purple blanket? Instead, seized an unremarkable purple blanket available at any number of retail outlets, and a rifle that Gatt had been previously purchased and registered at the direction of and with the assistance from LAPD officer. Boy said, y'all, if y'all wanted the purple blanket, you could have got it from any retail store. Not you roasting them for stealing your blanket. That was funny. You could get from any retail outlet. Okay. The result of this conduct was as devastating as it was foreseeable, given that Gatt is a celebrity whose earning capacity is almost entirely dependent on maintaining positive public perception. After defendant released a press statement publicly branding Gatt as a serial pedo, more than 200 different media outlets picked up the story and reported on the utterly false allegations. Gatt was immediately canceled in what had previously been a burgeoning acting career. I don't know if I said that right, but here we go. Was destroyed. Gatt's agent and PR representatives dropped him immediately. He was fired from two different movies. Oh, y'all gonna have to pay him money. He was fired from two different movies in which he had already been cast, and he was also recast in a third movie in which he had been hired to play the lead role. Moreover, at least two other movies he had already filmed almost totally cut his scenes or reshot them with different actors, and he was not invited to attend the premieres. Gatt immediately stopped receiving any further roles, offers, or audition opportunities, and instead received numerous death threats and was stalked and chased by a Daily Mail reporter. Jeez Louise. Now, what I will say is, do y'all remember Depp v. Heard? I know a lot of y'all know about Depp v. Heard. When Johnny Depp was like, he lost money because what Amber Heard did and said about him, but he didn't really have any movie roles lined up. This guy had roles lined up. So if he can prove his case, he is going to get money from the LA County. Okay. He won't have to act no more, even though he probably loves acting, but he won't have to act anymore. Anyways, for you, those of you that watch Game of Thrones or at least knows this actor from whatever other movies and TV shows that he does, I don't know. I don't know him from a can of paint. I don't even know what this guy looks like. Did y'all hear about this when all the allegations came out? I didn't, because I don't know him. But did y'all hear about this? Did you believe it? Let us know in the chat. Let's get back into it. Undeterred, defendants then compounded the damage to Gatt by continually and unreasonably delaying any continued investigation for more than a year, all while Gatt was silenced by order of the criminal court. He had a gag order entered as a condition of Gatt's bail at DDA Brunson's explicit request that prohibited Gatt from making any public comments via social media to defend himself. Throughout this time, defendants repeatedly failed and declined to produce to Gatt key discovery materials that exonerated Gatt. This stonewalling continued while Gatt learned through a private investigator he hired that DDA Brunson continued her personal vendetta against Gatt, had attempted to suborn perjury in an effort to have Gatt's bail revoked. A mere 6 days after these facts were revealed, Gatt learned that DDA Brunson had quit her job with the LA County District Attorney Office only after DDA Brunson resigned and after Gatt hired a private forensic investigator, Jeff Finchbach, to conduct his own investigation. Did defendant finally provide all of the electronic data they had seized and or obtained through search warrants, including forensic images of both Gatt's and Jane Doe's phones that the LADA admitted it had not reviewed. Not surprisingly, this evidence revealed that Jane Doe had entirely manufactured both her allegations and the photographed conversation to which the criminal charges were based. Miss Fishbach, is that how you say that name? Fishbach, that's not a cool name. Mr. Fishbach immediately sought to present his findings in open court to exonerate Gatt, but defendants refused to allow him to do so and voluntarily dismissed the utterly frivolous criminal charges on February 9th, 2024. What? They didn't even let him present evidence. They just was like, oh, never mind. We don't want to do these charges anymore. Go on, Mr. Alleged pedo. You lost all of your movie roles by now. So bye-bye. We're done with you. We are all done now. What? They just dismissed it? Matter of fact, we don't have enough evidence. You can go. Isn't that crazy? Good for him for filing this lawsuit. Even then, the LADA threatened Gatt and Finchbach with jail if they sought to make their findings public or if they spoke publicly about LADA. You can't do that. Or DDA Brunson specifically. In other words, defendant LA County explicitly threatened to further punish Gatt if he made any attempt to salvage his personal reputation and the career prospects that LA County itself had destroyed by charging him with crimes and publicly branding him a serial pedo without any evidence or probable cause. In stark contrast to the public announcement of the baseless arrest, defendants issued no press release upon the dismissal of the charges. Dang, y'all didn't even say nothing? Not surprisingly, while approximately 200 media outlets reported on Gatt's arrest, only one covered the dismissal of the charges. That's like career suicide. 200 outlets covered the arrest. One outlet covered the dismissal. That's intense, y'all. Gatt therefore files this action to recover more than $40 million in damages, and he has suffered as a result of defendants' violation of his constitutional rights. If he can prove his case, he deserves every single one of those dollars and more. If he can prove his case, which it sounds like they can, because they just dismissed these claims against him after they uncovered it. Reason why he's probably filing it in a lawsuit. I don't think he can get in trouble from talking about it if they just dismiss the case. He didn't sign anything. But with filing it in the lawsuit, he has the litigation privilege, so he can talk about these things. So it wouldn't surprise me if he doesn't take this all the way to trial. He just kind of wanted to get his story out, kind of like people assumed about the Cassie thing. But geez, Louise, that was a very, very, very strong opening statement, opening introduction, whatever you want to call it, for Deacon Fatal that said, are all entertainment attorneys spicy? This one is. This one for sure is. That introduction was like butter. Amazing. That was the best introduction that I've ever read on this channel. Seriously. Let's go ahead. I'm going to grab some chats and then we're going to get into the factual background because I know the chats are going to pile up on this one. So let's get Bossy B in here. We got JC saying, I do think Brandi is kind of a mess, but I don't believe Manzo. And so for y'all, I'm probably going to skip the Bravo one so that we can get through. Kayla Eloisa says, I mean, the books were never finished correct as far as Game of Thrones go. I don't know. Let us know. Phoenix Waller says to Kayla Eloisa, I believe GRRM is still writing them. Yes. Well, can they write it if the show already surpassed it? Small says Game of Thrones was fine, good even, until it wasn't. All the happy scroll says we could get another B-bomb. Yeah, we need another B-bomb. I love that. Mary Malaki says, let's make Bree's day / night. Yes, of course. I think we might be there. We might. Yes, we did. We hit it. So y'all know we got a warning coming through. We're going to play the second version of the like goal. We're at 102 likes. Shout out to the BriHive for exceeding our goals per usual. We love that for us. We are going to have a loud sound in 3, 2, 1. Shout out to the BriHive. Definitely appreciate it. Let's jump back into it. JC says, I never watched Game of Thrones. Okay, so we got some more non-watchers. Small says, when you grow up watching Shonda Rhimes storytelling and casting, it's tough to settle for less, right? All of the happy squirrel says to Kayla Eloisa, those books better be done before George shuffles off this rock. He says he's working on it, but it's been 84 years. Mary, shuffle off the rock. Mary Jane says, I need a badger emoji. Okay, Kayla Eloisa says, I was gifted the book collection but refused to start it. I'm a binger. I have no patience. You have to get through the whole thing, right? John Smith says he sounds pissed. Oh yeah, like this is intense writing. John Smith says, Monel implicates the state or organization for actions of employees for the other provision. Yeah. I just didn't know it off the top of my head. So thank you, John, for letting us know that. Kat McGowan says, well, thank you for the warning. I'm going to mute for a bit, but stay for the stream. Love that. It's just a quick second, like 3 seconds of explosion. All the happy squirrels says to Smalls, I struggle to believe the dude bros who made the series had GRRM's blessing after all that mess. I have no idea what you guys are talking about. John Smith says, wow, that's coming out swiney. Chris Mullen says they go after the celebrities deliberately because they can make a noise in the press with the cases. But if it's not accurate, you can't do that. Like Diddy stuff, okay. But this guy, they didn't even investigate. I know they didn't seize Diddy stuff. Are they going to wait a year to sit on that? I don't think so. Not with the feds, not with Homeland Security involved. John Smith says, I sense a lot of qualified immunity in the reply. Hey, maybe. Sakatoa says, what was it? Was it a waiting blanket? They took his blanket. Like, why would they do that? Kayla Eloisa says to Sakatoa, I mean, I would take a weighted blanket. It's for discovery purposes, not for your enjoyment. John Smith says, wait, this sounds like Bravo. It's not Bravo. Sakatoa says, I don't even remember this guy. I'll have to Google that. I love that. Never seen that. Thank you for letting me know what it meant. Chris Mullen says, I never heard of this one. It looks like it's a pretty new case. Kimmy found this one for us. I saw it, but it didn't pique my interest because I didn't know who he was. But Kimmy was like, told me what it was about. And I was like, okay, yeah, let's check that out. Joe W says, I hadn't heard of it. Okay, so not heard of the situation before this lawsuit. So Katoa says, yeah, don't remember his face. He was in all these movies. No one remembers my guy. John Smith says, oh my, malpractice anyone? You don't get shielded by that simply by being an actor of the state. Yeah, there's gonna be some defenses and there's gonna be some they're gonna be some unsuccessful ones. So I'm hoping that it kind of makes it through everything. Let's see here. Eloy says that's wild. I agree, it is pretty wild. Rachel Mills says things like this happen though all the time. I guess it depends on like if you're paying attention to that particular show, but I don't see stuff too much coming out as false with a celebrity. It's usually true, and it's usually a situation where you can believe it too. Sokatoa says, oh wow. Chris Mullen says, oh yeah, whoops, sorry, you can go now. We made a whoopsie. Sorry about your career and all. Sorry about your career and all, figure it out. Well, not sorry, not really. Please do not sue us. Please don't talk about us. They don't even want you to talk about them. LA County needs to get in contact with Jeanette, Braun, and Lauren the Mortician. You can't even speak on us. Eloy says, I hope he gets paid. I agree. Upside Down says, nuts. Agreed. Chris Mullen says, I hope he gets all the money. I am in agreement. John Smith says the order for bail seems like it was his only restriction. And isn't that so messed up? Like at the end of the day, I feel like they knew they were wrong and they were like, okay, well, we still need to silence him, but we'll let him out because we know he's not really a pedo, but we don't want him talking and telling everybody that he's not, right? That's crazy. All the Happy Squirrel says, holy hell, that's a whole lot of yikes. It's bad. It's bad. I was not expecting it to be this bad. Rachel Mills says, okay, the press thing, that's beyond the DA's office power. Media would rather expose a child, rather than exonerate them. Yeah, I agree with that. But also, there should have been some light shed on the DA for that. And the other thing about it is since Gatt never got to show why the evidence was bad, maybe a lot of the media didn't pick it up because it was no slander against the DA, right? If more information would have gotten out, then it would have been more slander against the DA, as we see a lot of articles popping up about this lawsuit even being filed. But an arrest is a lot more salacious than charges being dismissed, and we don't know why they're dismissed. They never got to present the evidence. Phoenix Waller says, I mean, it's GRRM's intellectual property. He licensed to HBO, not the other way around. Okay, Chris Mullen says the final Game of Thrones book has still not been released. The books follow a slightly different storyline and have more characters, so we'll probably not end the same way. That's hard for me to follow characters in books. Is that bad? Does that make me a bad reader? Rachel Mills says, I always forget which character is what. Rachel Mills says, with Johnny Depp, the press jumped on him being accused of abuse, but when he won his case, they were not in his corner. Yeah. I honestly think both of them were a little loco. Just a little. Both of them had a little bit of loco-ness going on, but I think Amber Heard just had more loco-ness. Chris Mullen says, yeah, they probably just saw, a celebrity accusation. Let's go get that guy. Then failed to do the due diligence, which in my honest opinion, they should have done first prior to the arrest. Yeah. Which we see them doing with Denny, right? They're raiding things. They got ideas, but they're not arresting him yet. All the Happy Squirrel says, if I were to speculate, I'd say the DA didn't even release a statement because the media would run LA County DAs effed up big time again. I'm sure it's not the first time, right? I can't think of anything off the top of my head, but they kind of mess up a lot of things. All the Happy Squirrel says, Kimmy is the real MBB tonight. Yes, she is. I agree with that. Kimmy Locker says to all the Happy Squirrels, aw shucks, just doing my job. Love that for us. Mary Malarkey says Kimmy Locker is definitely the MBB. And extra points for bringing back the honey badger meme. John Smith says Robert Jordan wrote a series of books but kicked the bucket before finishing. The estate hired ghostwriters, then sold the rights on Amazon to make movies. Interesting. That's interesting. Okay, let's jump back into the case and see what's going on further. Okay, well, let's get back into it. We got a lot to get through here. Let's go. Okay, so I'm going to be reading for a while, y'all. I'm sure it's going to get even better for us, but let's see. Okay, Gatt's background. Gatt was born and raised in London and moved to Los Angeles in 2005 to pursue an acting career. Before being targeted by defendants, Gatt was a successful actor with numerous film and television series credits, including Game of Thrones, Banshee, Thor. Oh, he was in Thor. Star Trek Into the Darkness, Dumbo, NCIS, New Orleans, Z Nation, True Detective, The 100, Teen Wolf. Oh, he was in Teen Wolf, and many others. Wow, he was in a lot of stuff. Gatt is also well known for his voice and motion capture performances in video games, most notably God of War and Star Wars The Old Republic. A lot of roles. Gatt was also a particularly well-known member of the high-performance sport cars community in the Los Angeles area, as Gatt owned and raced a Ford Shelby GT500, and as a known celebrity, was sponsored by numerous entities, including WRT Technica and Motorsports tuning shop that Gatt frequently utilized. So that's his IMDb. What's the order? IMDb? Whatever. It's his stats, right? The baseless criminal complaint against Gatt. The criminal complaint against Gatt, which was signed by Detective Amarantos and DDA Brunson under LA District Attorney George Gascon's name, alleged that Gatt electronically communicated with a minor in actually explicit manner. These charges originate entirely from the unverified story of Jane Doe, and then a then 16-year-old whom Gatt did not know and has never actually met, and whom defendants did not even bother to interview or even remotely access for credibility until almost 1 year after arresting Gatt and prosecuting him. More specifically, in October 2020, the boyfriend of one of Jane Doe's sisters sought to surprise Jane Doe, who was a big fan of Gatt, by contacting Gatt through the application Cameo to purchase a short video in which Gatt wished Jane Doe a happy 16th birthday. Shortly thereafter, Jane Doe, who lived in the state of Washington, reached out to Gatt via the social media application Instagram to thank him for the Cameo video. In the 2 to 3 months following the Cameo message, Jane Doe contacted Gatt on a few occasions via Instagram, and Gatt, whose earning capacity is tied to at least in part on various measures of his social media engagement, responded in a manner that was wholly appropriate and consistent with typical celebrity fan exchanges. Those communications were completely innocuous, and LA County does not allege that they constitute any crime. So basically, he's saying he made a Cameo video where celebrities can make personalized videos for fans. And someone bought it for her, and then she messaged him on Instagram, and he messaged her back, just kind of responding to a fan. Nothing inappropriate is basically what he's saying. Unbeknownst to Gatt, throughout the time, Jane Doe was an admittedly obsessed fan who was already using a naked picture of Gatt, a still image from his appearance on the television show Banshee that Jane Doe herself had apparently sought out and downloaded from the internet as her phone lock screen, even before Gatt had ever had any interaction with her. Where's her parents? Why does she have a naked man on her lock screen on her phone? Where's her parents at? Gatt also learned much later that Jane Doe had professed that she had actual dreams involving Gatt, and had also apparently downloaded from the internet pictures of Gatt from his appearance on the television show Z Nation, and photoshopped a fake tattoo of her own name onto Gatt's right bicep. This does sound a bit obsessed. Without Gatt's knowledge, and apparently using software readily available on the internet for the specific purpose of creating fake social media conversations to trick and impress friends, Jane Doe thereafter wholly manufactured fake conversations between herself and Gatt via the social media platform Snapchat that were actual in nature and pure fantasy. Now I'm saying, where is her parents at? I'm wondering if her parents found this and then reported it to the police, and then she had to tell the story. And she couldn't tell her parents, oh, this is all fake so I can impress my friends. So she had to say, oh, yeah, he's sending me this stuff. I'm wondering if that's what happened. Let's keep going. The facially untrustworthy evidence of the alleged Snapchat conversation. One of Jane Doe's older siblings apparently found, One of Jane Doe's older siblings apparently found these fake Snapchat conversations, and on or about April 7, 2021, reported them to Kent County. I thought it was the parents, but it's the older sibling. And again, I ask, where are your freaking parents? Washington Police Department via email. In doing so, Jane Doe's sister did not present Kent County PD with Jane Doe's phone or any electronic data downloaded from her phone. And instead simply used her own phone to take pictures of Jane Doe's phone screen where the fake messages were displayed. Jane Doe's sister then uploaded the photos to Google Drive and provided a link to the folder in her email to Kent County PD. The photos on the Google Drive were obviously a picture of one phone taken from a different phone, precluding the examination of any metadata that could prove or disprove the authenticity of the alleged Snapchat conversations. True. The pictures provided to Kent County PD also included 2 photographs of men with no clothes, no face shown, and no exposed genitalia. Gatt is not the man depicted in these photos, and because Jane, how do we know? How we know, Gatt? You got to explain to us why your body is different than his body. And because Jane Doe's sister only uploaded pictures taken of different phone screens and not the actual images from Jane Doe's phone, defendant could not, based on these photos alone, authenticate the photographs, identify the man or men pictured therein, or verify the image's source, and thus law enforcement could not have, based on those photos alone, confirm whether Gatt was actually the person depicted in either photo. My thing is, how your older sibling catch you and not your parents? And then you're too embarrassed, allegedly too embarrassed to say, oh, I lied, that's just me being weird. You just go with the story. Like, that's so bad. Or maybe she didn't know her sister told. Maybe only her sister told, and LAPD was like, oh yeah, let's go after this guy. What the heck? Let's get back into it. Other than the Snapchat conversation that Jane Doe had faked, the only alleged tie to Gatt was the fact that one of the photographs depicted an unidentified and faceless man lying on top of a plain purple blanket. This is the weighted blanket y'all have been waiting for. A plain purple blanket, one readily available for purchase by anyone at any time on Amazon or at numerous other stores that looked similar to the blanket that could be seen in the background of picture Gatt had previously publicly posted of himself on social media platforms. Importantly, even a cursory review of the pictures that Jane Doe's sister provided to Kent County PD reveals that the conversations are highly suspicious on their face. Many of the pictures include snippets of the same conversation thread, yet in each different picture, this same prompt is immediately followed by radically different responses, as if Jane Doe tried numerous times to find the most believable ones. Once again, numerous different software applications are readily available on the internet that are designed specifically for this purpose. For example, at least 18 pictures relate to the same alleged conversation where Gatt supposedly told Jane Doe that he and his partner of 14 years, Mercy Malik, had a personal arrangement that permitted Gatt to pursue other relationships. Other relationships with children, though? Come on now. That conversation never happened. Jane Doe created it from thin air. Each of these 18 pictures includes all or some portion of the same alleged interaction where Gatt supposedly said, "We have a personal arrangement," and Jane Doe responded to say, "Oh, okay, I see. But yes, to clarify what you said." Despite this, all 18 pictures then display entirely different alleged responses to the same prompt that conflict with one another and often do not make any sense in context. These are some examples. We got Joey G on Snapchat as a celebrity talking to her. I guess so. Does Mercy know? Joey says, "I have a personal arrangement." The girl says, "Oh, okay, I see. But yes, to clarify what you said." Joey says, "Some work on the computer editing some pics. Why?" And then the girl says, "Me just wondering." And then another one says, after the 3 messages, "How's it going? You disappeared." Her saying, "Everything is good. Everything is going good. Sorry I was not home and was busy cooking and other stuff. I just got home." Literally the same sentences. And then, "I just want to make you smile," from Joey, and the girl saying, "I already do." And then another one, and then just a bunch of these screenshots that really don't, I mean, I guess you can message different times, but my thing is, but also with Snapchat, they can normally delete. So maybe they're not always coming directly after. Maybe she let some of them delete. So that argument to me doesn't all the way make sense if you know like Snapchat. I haven't been on Snapchat in years though, so I don't know if things change if all conversations are automatically saved or if you have to fix it to make it up. You have to save each message. So she says, why is that funny? He says, why is that funny? She says, you're so comfortable doing that. Well, I guess you've earned because you've been working out. Another one, Joey saying, okay, I'm confused because I thought you changed your mind and wanted to see my male genitals. And she goes, I don't want to see your male genitals yet. Yet. Okay. Joey says, I wanted to show you my whole body. She sent a laughing emoji. And then he goes, 7 more of the screenshots relate to different supposed threads. One that, again, never actually happened, where Gatt allegedly wished Jane Doe Happy New Year. But I guess she would have to screenshot each one because I'm like, oh, well, it could be automatically deleted. But I guess she would have to screenshot each one. I don't know. Either way it goes. Let's see. Where was I at? 7 more of the screenshots relate to a different supposed thread. One that, again, never actually happened, where Gatt allegedly wished Jane Doe Happy New Year. And Jane Doe responded to say, thank you, Happy New Year to you, and mercy. Once again, each of these different screenshots contain one or both of these statements, yet the responses and replies from there are explicitly dramatically different, contradict each other, and often make no sense in context. I think to resolve that issue, to tell you the truth, is if she just kind of screenshotted them as she went through and she was just letting them automatically delete as Snapchat does. After you see it, it deletes, right? They just talk about different stuff, video chatting soon, asking her if she's wearing anything, and then she said nothing. And then he says, you didn't want to see me naked. And she said, well, I guess. Okay. Even a cursory review of these screenshots reveal unreconcilable conflicts that simply would not exist if the conversation were legitimate and had actually occurred. Again, I don't think that's the strongest argument because Snapchat does automatically delete messages and she could be screenshotting each one. But I just assume every program alerts you when you're screenshotting things, but I could be wrong. Despite this, and as explained further below, nobody with either the Kent County PD or defendants bothered at any time to review or forensically examine Jane Doe's phone to verify whether these conversations were legitimate and actually took place or were instead simply fantasies concocted by an admittedly obsessed fan trying to trick or impress her friends before recklessly destroying Gatt's career. That sucks. And she's a teenager. And she did all of that to this man's career. Kent County PD investigates Jane Doe allegations. On April 8th, 2021, just one day after Jane Doe's sister sent her email containing the Google Drive link to Kent County PD, a Kent County PD officer responded to the email seeking to set up an interview with Jane Doe. Perhaps now realizing that the conversations had been fake, that same day Jane Doe's sister immediately declined to cooperate and told Kent County PD, at this time, no further assistance is needed. The Kent County PD officer explicitly noted in his case report that he did not find probable cause of a crime regarding the messages. So Kent County said no. Okay, she didn't want to be interviewed. Approximately 1 month after the initial report, Kent County detectives ultimately decided to again attempt to interview Jane Doe. This time, Jane Doe's brother-in-law presented Jane Doe for an interview on or about May 5th, 2021. In that interview, Jane Doe confirmed that she was a fan of and had a crush on Gatt. Also during the interview, and perhaps in an attempt to cover up the fraudulent nature of the photographs that her sister previously had provided to law enforcement, Jane Doe falsely accused Gatt of engaging in electronic communication with her that were actually explicit in nature. Because the alleged crime was conducted solely by electronic means, there were no alleged in-person meeting. The truth or falsity of Jane Doe's accusation easily could have been determined by an examination of her cell phone and computer records. However, Kent County PD inexplicably failed to take this rudimentary step in the investigation. Kent County PD refers its incomplete investigation to defendants. So, At first, they didn't interview her, then they interviewed her, and then they sent the case to LA. Before completing its investigation and after learning that Gatt did not reside in Washington, Kent County PD referred the matter to LADA and the LAPD in December 2021, approximately 8 months after the initial report was made in Washington. LA County DDA Angela Brunson took over the investigation in collaboration with LAPD Detective Dinos Amarantos, who was employed by the city of Los Angeles and was simultaneously acting as an agent of the LADA and thus defendant LA County. In a clear violation of the State Bar California ethical rules and LADA policies and procedures, the former of which prohibits prosecutors from proceeding with charges that the prosecutor knows are not supported by probable cause and from failing to timely disclose exculpatory evidence or evidence that casts significant doubt on the accuracy of the witness testimony, and LADA policies and procedures explicitly prohibit law enforcement officers from permitting personal feelings, prejudices, political beliefs, aspirations, animosities, or friendships to influence decisions. DDA Brunson began working on the case despite knowing Gatt and having personal bias and animosity towards him, which Gatt did not learn of until much later. Why does this lady not like you? DDA Brunson's transparent yet undisclosed conflicts of interest are clearly reflected in her malicious, reckless, and/or negligent action upon taking over Gatt investigation. Even though it was abundantly clear that Kent County PD's investigation was incomplete because it had not included the review of any electronic or online data for this allegedly electronic crime, nor had Kent County PD attempted to corroborate Jane Doe's statements or authenticate the pictures they were provided, defendant undertook no investigation of their own and instead relied entirely on an incomplete record that had been developed by Kent County PD to that point in a clear violation of LADA policies and procedures. So they just took Kent County's word for it. Let's see what else they have to say. LADA policies specific to alleged X crimes. I guess I see. Yeah. Anyways, crimes provide that the alleged victim shall be interviewed before filing and further require the deputy to assess the alleged victim's credibility and determine whether any corroborative evidence exists to support the allegations. Completely disregarding these policies, DDA Brunson failed even to interview Jane Doe, a witness who had admitted to Kent County PD that she was a fan of and had a crush on Gatt, to judge her credibility before arresting Gatt or charging him with a crime, and defendants further failed to make any attempt to review any electronic or online data that might corroborate or refute her allegations. These failures are even more egregious in light of the glaring inconsistencies in the pictures of the fake Snapchat conversations that formed the entire basis of the investigation and the defendants utterly and recklessly ignored. Moreover, approximately 2 weeks after the arrest, defendants received the return of a search warrant issued for Apple for Jane Doe's iCloud data, which included notes in which Jane Doe stated she kept having dreams about Gatt that were flirtatious and sexual. Despite this, defendants still declined to interview Jane Doe and did not produce this data to Gatt until July 2022. So when did they get it? They got it. It didn't say when they got it. Either way, they delayed in giving it because this all happened in 2021. They delayed getting it to him till mid 2022. Incredibly, even though they were investigating an alleged electronic crime involving alleged conversation occurring online through social media, defendant apparently either did not even bother to obtain and review a forensic image of the contents of Jane Doe's phone, or even worse, actually received such forensic image from county law enforcement, yet declined to review that image or any other electronic or online data to see whether it corroborated or refuted Jane Doe's otherwise unverified story. On or about March 24th, 2022, Detective Amarantos issued his first report on the investigation, which conceded that defendant did not interview Jane Doe or any other witnesses, and further indicated that in clear disregard of the clear and complete nature of the Kent County PD investigation to date, defendants were instead proceeding entirely on the sparse and demonstratively untrustworthy information previously collected by the same Kent County law enforcement personnel who themselves had declined to prosecute Gatt. Well, if it didn't happen in their I guess it's sending a text message there. It would be better dealt with in LA anyway. So I'm not all the way there on that line, but I see where they're going with that. Defendant used that facially untrustworthy information as the basis for a criminal complaint against Gatt, which was signed by Detective Amarantos and DDA Brunson on behalf of defendant Gascon on or about April 1, 2022. Defendant Amarantos also signed a search warrant affidavit that for Gatt's residence the same day. Defendant did not identify or acknowledge any of the above blatant inconsistencies or contradictions when seeking and obtaining the warrants that led to Gatt's arrest and the search and seizure of his residence. In doing so, defendants recklessly ignored the lack of any probable cause and failed to conduct any meaningful investigation into this unreliable and untrustworthy evidence. Thus, while Gatt's arrest, search, seizure, and detention were all purportedly based on a warrant or information and belief, defendants obtained those warrants based on misrepresentations and or omissions material to the purported finding of probable cause, including without limitation, intentionally and maliciously relying on and or acting with reckless disregard for the truth of the fabricated nature of the supposed Snapchat conversations that formed the entire basis of defendant's investigation. Acting with knowledge that the pictures of these supposed Snapchat conversations were not reliable, credible, or trustworthy on their face, and ignoring glaring red flags about the reliability of this evidence in the form of facial inconsistencies and statements that made no sense in context. Refusing to obtain and or refusing to review once obtained critical electronic data underlying the supposed electronic communication that would have proved the fabricated nature of the alleged Snapchat conversation. Refusing to themselves interview Jane Doe, an admittedly obsessed fan, to assess her credibility or attempt to verify her allegations, and intentionally concealing the bias and personal animosity the DDA Brunson held towards Gatt to obscure the bias and animosity, the lack of any true investigation before obtaining warrant despite the lack of any probable cause. Defendants knew or should have known that the pictures and other information they utilized were unreliable, not credible, and untrustworthy, and cannot serve as a basis for finding probable cause. Defendants thus engaged in judicial deception by obtaining the warrant on the basis of material misrepresentations and omissions that they knew or should have known were false. And these misrepresentations and omissions were made intentionally as a result of personal bias or animosity, or alternatively, with reckless disregard for the truth based on the totality of circumstances. No reasonably prudent person could have concluded that probable cause existed based on the information provided. That's a lot. This lawsuit is a mouthful, okay? I don't even know if we're close to getting to the end of the stuff. Let's see here. We got a little while to go. Let's see. I'm just trying to see how far we have. I don't think I'm going to be able to make it through this, y'all. We got quite a bit to go. Let's go ahead and let's see. Let me try to skip through it if I can find the ones that matter. Okay, let's talk about the bail conditions on Gatt. I think that's an important one to consider. So defendants imposed and weaponized bail conditions on Gatt. Although Gatt was released on bail after his arrest, one of the principal conditions that DDA Brunson insisted upon for his eligibility for bail was that he was prohibited from making public statements via social media, and the criminal court ultimately ordered Gatt to refrain from using social media or anything other than work purposes. As a working actor who relies heavily on public interaction to maintain popularity and thus eligibility for future roles, this prohibition was essentially a career death sentence, particularly after defendants sought to weaponize the bail condition to further damage Gatt's reputation and career. Approximately 1 week after Gatt's arrest and having still not interviewed a single witness or even bothering to collect or review critical electronic data that could have immediately demonstrated the fabrication of the alleged Snapchat conversation at issue, defendants issued a public statement seeking to identify any additional victims of Gatt, describing Gatt's alleged engagement in online sexually explicit conversations with a minor across state lines, and setting up a tip hotline. In other words, based solely on the allegations of a single admitted obsessed 16-year-old fan whom they had never bothered to interview to that point, along with facially untrustworthy photographs of the alleged Snapchat conversation with that fan that they made no effort to verify against the actual electronic online data. Okay? As a result, his career it devastated his career. In 48 hours, 120 different media outlets picked up the story and reported the false allegations. His PR team dropped him. Let's see what else there was. Even though Gatt reported he was getting stalked by the Daily Mail reporter, even though he reported the stalking and the car chase, LAPD, they refused to take any action. Not surprisingly, because defendants had insisted on a court order silencing Gatt as a condition of bail. Gatt was entirely unable to defend himself. Let's see. More specifically, DDA Brunson learned that Colin McCarty, an employee for WR Tanika, who knew about DDA Brunson and Gatt, had published an Instagram story that Gatt was trying to maintain professional relationships with his former sponsors. He responded to with a single word, "Yep." Within hours of this occurring, DDA Brunson filed a motion to revoke Gatt's bail and attach a picture of a phone reflecting Gatt's comment. Another picture of a phone? Like, does the DA not have any better evidence than pictures of phones? DDA Brunson filed declarations signed by McCarty identifying Gatt's social media posts and claiming that McCarty had reported it to authorities after learning of Gatt's bail condition through new posts, even though no media outlets had ever reported on these restrictions. DDA Brunson personal animosity and bias towards Gatt is revealed. And so I wanted to get into this part of it. Given the highly suspicious nature of McCarty's declaration, Gatt retained a private investigator who interviewed McCarty. From that interview, Gatt learned for the first time that DDA Brunson was in a romantic relationship with Justin Badarnero, who worked with McCarty at WR Tanika, the tuning shop that Gatt frequently used and that had served as Gatt's primary sponsor before his arrest. McCarty also revealed in this interview that DDA Brunson was like Gatt himself, an active member of the high-performance sports and car community and frequent attendee at events held in RW Tanika. In other words, DDA Brunson had a previous undisclosed personal connection to Gatt that preceded the beginning of her involvement of the investigation. During the interview with Gatt's private investigator, McCarty candidly admitted that despite the claims DDA Brunson made in the previously filed motions to revoke Gatt's bail, McCarty had never told LA County that he found out about the Gatt's bail conditions through news reports. McCarty further confirmed that he was friends with DDA Brunson and that he had likely learned of the bail conditions either from DDA Brunson herself or from Badarnero, DDA Brunson's boyfriend, and McCarty's co-worker. McCarty further stated that he was not the one who had reached out to LA County. Rather, he had shown the direct message to Badarnero, and DDA Brunson had reached out to him about it a short time later. McCarty also admitted that DDA Brunson had drafted his declaration, which contained statements she knew to be false about how McCarty had learned of Gatt's bail condition and what had happened once McCarty saw Gatt's Instagram post. DDA Brunson thus had personal and undisclosed connections not only to a key witness she presented to the court, but also to Gatt himself, the target of her ongoing criminal investigation, all in violation of numerous LADA policies and procedures that prohibit, among other things. But if he, they got more information. Because I was like, but if they sponsored him, why would they be trying to jeopardize his career? As Gatt later learned, DDA Brunson apparently knew Gatt long before she took over the investigation and frequently attended where is that? Frequently attended events where he was also in attendance, yet did not disclose these facts to Gatt, his criminal defense lawyers, or the court. Indeed, DDA Brunson frequently made public social media posts supporting WR Tanika and high performance sports car community, the high performance sports car community generally. From those posts, Gatt learned that DDA Brunson, who races a Hyundai, was seeking sponsorships for her race car, that she was jealous of others like Gatt who had obtained sponsorships, and that Brunson's dream car was a Ford GT similar to the Ford Shelby GT 500 that Gatt owned. Brunson's fascination with Gatt and his car is apparent from her social media posts, one of which even has Gatt in the background and was taken at WR Tanika event and occurred approximately 1 month after DDA Brunson took over the investigation, but before Gatt was charged and arrested. DDA Brunson was desperate for attention and sponsorships and sought to raise her profile as reflected by her social media postings below and her appearance on podcasts discussing her work as a DDA, during which she complained about her DDA salary. In doing so, DDA Brunson portrayed herself in a particularly unprofessional manner, including by publicly posting pictures which are sexual in nature and were especially inappropriate given her role in prosecuting sex crimes in LA. Okay, so I guess, I don't know, is that her? And there's a sock that says slut. I don't know. Are those her legs? They think this is a provocative pose. Interesting. And her shirt says love male genitalia. And we got her posing on top of some motorcycles. We got her posing in the sexy outfit. Again, on a car, sexy outfit. That's her Hyundai that she races, I guess. And then in the shop. And then that's pretty much it. So he's saying that she wanted to take him down so that she can lose one competitor and potentially get his sponsorship. Is that what he's alleging? Moreover, Gatt was well known in the high performance sports car community generally, and to DDA Brunson specifically for his liberal political beliefs, including his vocal support for the Black Lives Matter movement and the LA County District Attorney George Gascon. Like the vast majority of the high performance sports car community, DDA Brunson espouses conservative political beliefs that are the popular opposite of Gatt's belief. And she was also a vocal critic of Gascon, despite working for him at the LADA. For example, media outlets have previously reported DDA Brunson's exasperation at Gascon after he issued a special directive forcing her to strike priors in the case of a parolee caught in possession of child CP, and her request that the judge deny the motion she herself had made at Gascon's direction. DDA Brunson, who follows at least one anti-Gascon social media account, herself made a social media post about this issue and also made public statements to the effect that she would be surprised if there were 10 people in LADA who approved of Gascon's policies. They have Man's sentence for possessing CP. Given her political beliefs and Gatt's reputation as a liberal and Gascon's supporter in their shared community, including the connection to her boyfriend's employer, DDA Brunson clearly already had personal animosity towards Gatt at the time this matter was referred to LA County. Remarkably, however, DDA Brunson never revealed her personal connections and clear conflicts of interest to the court, Gatt, or the criminal defense counsel. A mere 6 days after Gatt's private investigator interviewed McCarty's, who admittedly knew DDA Brunson well and on information and belief told her about the interview and uncovered evidence that DDA Brunson's connection to McCarty and WR Tanika and personal animosity towards Gatt, Gatt learned that DDA Brunson had quit her job with the LADA and had taken a position with the Riverside County District Attorney Office. So she quit her job. Gatt hires his own forensic examiner. Okay. I feel like this is going to be important, but I really don't got it in me, y'all, to finish this. Like, look at this. I know he suffered substantial damages. Okay, it's almost done. Do I have 3 more pages in me? I don't know. But I think this is going to give us a lot of information. I think this is going to give us a lot of information if we go through this one. So let me do this last section. We know he already lost movie roles, so we're going to skip that last little short section. But let's get into what they discovered when he did the forensic examination, y'all. We are almost 3 hours in. If y'all haven't hit the like button and you are here, please do hit the like button to give me a little bit of encouragement and to help out the stream a little bit. Let's get into what the forensic examiner found in the case. Only after DDA Brunson quit her job did the LADA finally produce critical Brady materials that DDA Brunson had previously withheld for as many as 20 months after Gatt was arrested, and defendants publicly branded him as a serial pedo. Indeed, Gatt ultimately had to retain his own private forensic investigator, Jeff Fishbach, to ensure that defendants conducted a proper investigation of the electronic communications at the heart of this case in order to finally prove Gatt's innocence. However, once DDA Brunson resigned and a new prosecutor, DDA Michael Fern, took over the case, the LADA finally provided the required Brady materials after repeated urging from Mr. Fishbach and from Gatt's criminal defense attorney. First, on December 13, 2023, so god dang 2 years later almost, the LADA provided portions of the discovery received and which the LADA claimed it had not reviewed in response to search warrants issued onto Instagram and Google for records relating to Gatt. 2 days later, on December 15, 2023, the LADA provided additional Brady materials regarding the returns of search warrants issued to Jane Doe's Instagram records. Finally, on January 19, 2024, nearly 2 years after arresting Gatt and charging him with electronic crimes, the LADA produced still further Brady materials consisting of a report detailing the results of a forensic examination of the phone that purportedly belonged to Jane Doe, though the report does not indicate whether this was the specific phone of Jane Doe supposedly used when allegedly communicated with Gatt via Snapchat, or when the LADA first received a copy of the phone or its contents, other than a note that the forensic image was originally provided to defendants by Kent County law enforcement. The LADA never produced to Gatt a copy of the actual evidence it had received from Kent County law enforcement, nor did it ever tell Gatt when it received the evidence. This information defendants provided between December 13 and January 19, 2024, and which defendants either already had or should have obtained long before they finally provided Gatt the information he needed to clearly and conclusively establish that Jane Doe had manufactured the utterly fake electronic communications that formed the sole basis of Gatt's arrest and public humiliation at defendants' hands. Gatt's forensic examiners, Mr. Fishbach, thoroughly reviewed these materials, which defendants should have obtained before ever arresting or charging Gatt, and certainly before recklessly branding him as in the public as a serial pedo, and found that only the conversations between Gatt and Jane Doe were the Instagram conversations about Gatt's cameo video and other innocuous Instagram conversations otherwise common to any celebrity fan interaction. Let's see. Notably, none of the fake Snapchat conversations featured in the photographs that defendants utilized to arrest Gatt were found on Gatt's phone or computer forensic, nor were they found on Jane Doe's phone's forensics. That said, and still further evidence of Jane Doe's obsession with Gatt and her alteration of photos and other electronic data, the forensic review of Jane Doe's phone did reveal that Jane Doe had herself downloaded from the internet still shots of Gatt from his role on the television show Z Nation that Jane Doe had apparently photoshopped to place a tattoo of her name on Gatt's right bicep. The forensic examination of Gatt's and Jane Doe's phones clearly established that the supposed Snapchat conversation that constituted the alleged crime simply never happened and were instead the product of the overactive imagination of an obsessed fan who had herself previously and unilaterally sought out and downloaded new pictures of Gatt from his appearance on the television series Banshee to use as her lock screen photo even before her first interaction with Gatt through social media. Defendants would have known these things had they bothered to conduct even the most rudimentary electronic investigation of the facts and evidence, and this alleged electronic crime provided to them by Kent County law enforcement, who themselves declined to prosecute Gatt, rather than blindly proceeding in a vindictive and personally conflicted attempt by the DDA Brunson to maliciously and recklessly destroy Gatt's career. All of this information was readily available to defendants, yet at best, defendants declined to obtain or review it until they were repeatedly pressed into doing so by Gatt's own forensic examiner more than a year after defendants destroyed Gatt's reputation and career, or at worst, defendants knew this information yet proceeded to falsely charge and publicly humiliate Gatt purely out of personal animosity. If that's true, that sucks. After viewing the newly produced forensic evidence, Mr. Fishbox prepared an 82-page PowerPoint presentation that thoroughly detailed his findings and explained how Jane Doe had manufactured the forged images, something that would have been obvious to defendants months earlier had they properly investigated these charges. This is particularly true given that none of the materials provided by Jane Doe, who again defendants did not bother to interview until nearly a year after arresting Gatt and charging him with electronic crimes, contained any pictures that included Gatt's face or otherwise conclusively identified Gatt. And because the screenshots of those fake conversations were replete with facial inconsistencies and contradictions, had defendant exercised even minimal diligence and forensically examined Jane Doe's phone and or reviewed search warrants returned for her or Gatt Snapchat or Instagram records, defendants would have known from the start that they were dealing with an obsessed fan, that Jane Doe allegations were false, that she was not a credible witness, and that defendants lacked any semblance of probable cause. Shortly after Mr. Fishbox provided this PowerPoint presentation to the LADA, he asked to present his findings in open court at a preliminary hearing in an attempt to clear Gatt's name of the baseless charges that had been recklessly and maliciously asserted against him. The LADA sought to prevent Mr. Fishbox from openly testifying at all costs, first by offering to stipulate to unspecified limited testimony from Fishbox, and then by accusing Mr. Fishbox of trying to embarrass you guys are trying to embarrass me. Y'all didn't already embarrass Gatt? Come on now. That he's trying to embarrass LADA. Ultimately, the LADA dismissed all charges against Gatt on February 9, 2024, and further asked the judge to bar Ms. Fishbox from taking the stand to publicly present his findings regarding defendants' utterly deficient investigation and the complete fabrication of the supposed evidence underlying frivolous charge against Gatt. Immediately following the hearing, LADA threatened Gatt and Mr. Fishbox with jail if they sought to make their findings public and if they spoke publicly about the LADA or DDA Brunson specifically. In other words, defendants explicitly threatened to further punish Gatt if he had made any attempt to salvage his personal reputation or career prospects that defendants had themselves destroyed by charging Gatt with crimes and publicly branding him as a serial pedo without any evidence or probable cause. He suffered irreparable damages. He lost movie roles. He cannot work as an actor since the arrest. He lost all ability to earn as an actor. He also had to sell his prize Ford Shelby GT 500 at a fire sale price because reputable auction houses were not willing to work with him just to have enough money to pay for his criminal defense costs. So he's going ahead and suing them. I don't get how they even threatened him at the end of it to say, oh, if you sue us or if you talk about us, we're going to charge me with what? Charge me with what after that? Okay, y'all, we got some chats to get through. So let's go ahead and have Bossy Bree bring us in. Y'all, we are at a 3-hour live stream on Thursday. All right, let me know y'all's thoughts. We are going to go through the comments. I probably won't make a lot of commentary on the comments, although I always say that and then I do because I'm tired. I am tired and I have to be up pretty early in the morning. So let's go with the chats. Look at my eyebrows all crazy. Rachel Mill says it has nothing to do with celebrity. It depends on the crime. When they involve children, the DA/police would rather go oopsie than have something happen to more children. I agree with that. Chris Mullen says, I have heard of Joseph Gatt, but most of these accusations, but not the accusations against him. Okay, makes sense. Mary Jane says, OMG, where are the parents? The parents are non-existent. It's the older sibling that's telling this. Chris Mullen says, the lesson here is get your personal assistant to do your social media. Never do it yourself. Celebrities need to be super careful with their fan interaction. The best way, sadly, is to not engage. I thought that assistants did do things like that. And I didn't think that responding in DMs was part of engagement, but I guess it is now, right? All of the Happy Scroll says to Chris Mullen, Hot Mess is accurate and bland, predictable, and more focused on effects than storytelling or plot, right? All the Happy Scroll says they didn't. They did. They didn't even get her phone. No. And when they did get her phone, they never passed the evidence over to him. Upside Down says, not that difficult to use a template and create anything you want. Her parents would have no clue. The fact is that she had a naked man on her screensaver. Like, that's already doing too much for a 16-year-old. Mary Jane says, no, not the blanket. Yeah, he had a picture of the blanket and they were like, yep, he did it. Look at this purple blanket. John Smith says, kind of a shallow fake as opposed to a deep fake. Yeah. All the Happy Girl says, it's giving Amber Heard's evidence. Phoenix Waller says, it's giving clout chasing among peers that's got out of hand. Right. And her just like being in the same vicinity and like, oh, well, if we get him out of the section, maybe people will start sponsoring me. That's insane to think like that. Phoenix Waller says, look who I'm talking to on Snap. Look how spicy it is. I'm talking to the celeb and you're not. It's strange, but she's a little girl. John Smith says, welp, she is going to be on the stand in the near future. I mean, she's an adult now. She would be an adult now. Mary Malarkey says, forget. The suit alleges that the defendants failed to interview the fan until a year after Gatt had been arrested, charged with a baseless crime, and publicly branded as a serial pedo. Yahoo News. Thank you for the quote. All the Happy Girl says, wait, Kent County, Washington? That's not a thing. Where's Kent County, Washington? Is in Askin County, did Gatt's attorney not did they not do a little Googling? Did it say Kent County, Washington? I don't know. All the Happy Girl says King County, dang typos. It was Kent County is the one that who they got the information from. John Smith says, so let's ignore all the exculpatory evidence. Yeah. This foundation has a house on it already. I wonder if they make it into a mansion. Yeah, they're trying to. All the Happy Scroll says to John Smith, yes, it looks like the DEA in question has moved to another county since, and the LA Times quoted an anonymous person in that office who said they're investigating and it's likely to show there was bias with the DA. That's not good for them. They should be investigating though. Eloy says, imagine your whole life being blown up and you have to keep quiet for an undetermined amount of time. That's crazy making. That's what I'm thinking too. I almost would have just stayed in jail and talked my mess from the jail cell like, what's his name? The Tiger King. That's what I would have did. John Smith says, oh no, really? The car scene? Yeah, they were into the car scene. All the Happy Squirrel says, wait, so the prosecutor may have been motivated by car envy? What? Isn't that insane? Like, that's crazy. Kimmy Locker says, BriHive, there's a community post for everyone and make suggestions for BriHive bingo. Okay, so we'll do it next week. We'll try BriHive bingo next week for the first time. Thank you, Kimmy, for creating that poll. Eloy, or the comment, or what is it? Yeah, I guess it would be a comment, right? Community post. That's what it's called. Eloy says, yikes, this took a turn. It did. Phoenix Waller says, a high-speed turn. John Smith says, holy crap, instant fire. I'm in my jurisdiction. Yeah. All the Happy Squirrels, I don't really care about what she does in her off time, but like, girl, car scene mess, really? And you brought it into criminal court. Yeah. All the Happy Girl says, does she have a filter between her mind and her mouth? Because that seems pretty unprofessional. I would agree with that. All the happy squirrel says, hi, it's me, the one with the often malfunctioning mind mouth filter. Even I know not to talk smack about my boss on the internet. Isn't that wild? She was just going in on this guy on the internet. Yeah, you're right. Eloy says, now she's in my county. Great. You go visit her. She might put you behind bars. All the happy squirrel says, I just mind blown. Agreed. Upside Down says, like and sub. Thanks. Thank you for the reminder. Thank you. John Smith says, I know you have stuff to do, but it might be nice if you were to appear on Runkle of the Bailey on Mondays. Sometimes he does cover stuff you might know more about. I will be contacting Ian later because I need to send him the link for the timestamp. And the chat has already voted 3 hours ago that we have to do a Jeanette Braun stream together. So I will reach out to him. Sheila says, I know I shouldn't judge, but he does look a little shady. Okay. Kimmy sent me a link to what this guy looks like. So let's see. Okay. That one he has on makeup, so I'm not going to use that one. All of them are makeup. Oh, normal picture. And he is a little creepy looking. I mean, not to say that means he's a pedo, but let me. Why'd you send me this, Kimmy? This is him. He looks a little alienish, not to come for his looks or anything like that. So, I mean, shady? Yeah. Sheila says unique is more accurate. Shady was harsh. Yeah. Maybe unique. Maybe unique. You're right. Sheila says, good Lord, that was typed wrong. Unique is more accurate and shady was too harsh. It's okay. Yeah. He's a different looking character for sure. Okay. He had a lot of roles though. So I guess uniqueness is great. Kimmy Locker says, Sheila, I don't personally think he looks shady, but either way, there's a pretty big difference between shady and the accusations that were made. That's true. That's true. All the Happy Girl says to Sheila, he does have a unique look, like a washed out Dwayne The Rock Johnson wannabe who doesn't use the roids and whatnot. Yeah. I can see the similarities. All the Heaviest Girl says to Kimmy Locker, exactly. He looks kind of weird, but that doesn't make him a gross weirdo. Well, apparently, the DA was like, get him off of my scene so that I can be the new weirdo drive. Not make saying he's a weirdo, but she's like, get him off of my scene. He's too unique. Mary Malika says, is 110 likes a new record? On the live stream, I think since we've been doing the live goal, yes, I think so. What celebration shall we have? Kimmy Locker says to Mary Malarkey, good question. I actually don't know what our record is for a live stream. I think we've gotten more likes on a live stream before, but it's been like in combination with other people joining and different topics. So I don't know what I think since we've been doing the like goal and like really paying attention to the likes on the stream, this is our record. And I can't really go back and see where likes were at when it was posted, or I don't know how to do that at least. So I don't know. Tanya D says, I show 115 to Mary Malarkey. It might be. I know it has been about a year. It has been about a year at least. Yeah, this is the most that we've had in a long time. If anything, Eloy says, dang, salt in the wound, selling the car. Yeah, he had to sell the car. That is sad. All the Happy Girls, not the Tiger King. Yeah, I would have been talking my mess from the jail cell. I didn't do it. They're lying. Tiny says, I haven't heard about the Tiger King in ages. When the Panini came out, that everybody was watching that. Eloy says to Tanya D, the Tiger King comment took me out. Yeah. I'm just saying, like, I would want my free speech behind bars, I guess. Upside Down says, creepy, I'd be quickening my walk. He's an interesting looking character. I will give him that. Okay. Can we drop the banners? I can't pull them down. Let's see. Okay. Oh gosh. Go away the facts. All right, y'all. That is the end of the live stream. Your girl is tired. Shout out to the BriHive. I think we have hit a like goal record right now for our live stream. We are at 117 likes on the live stream. So shout out to the BriHive. Shout out. I'm not gonna do another explosion because I feel like it's getting too late to keep exploding over here. But shout out to y'all. Thank you for hitting the like button. Thank you guys for staying engaged for 3 hours of me talking and reading. Surprisingly, I feel like I did a really good job reading the last lawsuit because it was just so smoothly written. It was really good. I stumbled a little bit because I'm tired, but for the most part, ease. That one was ease. So thank y'all for sticking with me. I hope everyone has a wonderful, wonderful weekend, and I will see y'all all on the next live stream. However, Kimmy did post a community post for you to drop words that we should use in our bingo game cards that we're going to start doing on the live streams. And let us know. You make a comment as well. Let us know if you want your own individual bingo cards that you can download, or if you want us to just do one on the live stream. Which one makes more sense to you guys? Go ahead and do your vote. I don't know if we can like pin a comment for that part, Kimmy, for them to vote if they want their own individual cards that they can like download from a Google Drive link or something, or if they just want to do one together on the live stream as we go through cases. Don't know how we're going to incorporate that, but we're going to try. Again, thank y'all so much for staying on the live stream with me for 3 hours.